Good morning. Good morning, everybody. Namaskar. This is Engineer Suraj Singh speaking from Bharat, India on this day, November 22nd, 2021. मंडे। मैं सूरज सिंह सिविल इंजीनियर भारत इंडिया से बोल रहा हूँ। आज दिनांक नवंबर 22, 2021 सोमवार। एंड टॉक आपसे वार्ता इंटरेक्शन विद यू, टॉक विद यू अबाउट क्वालिटी, गुणवत्ता के बारे में, सेफ्टी के बारे में आपसे बातचीत। टाइटल इज़ सिविल फील्ड इंजीनियरिंग, combination of English and Hindi, but primary language is English. Hindi is for those who can know something about this, जो हिंदी जानते हैं, इंग्लिश नहीं जानते हैं या इंग्लिश को कम महत्व देते हैं, ऐसे लोगों के लिए मिलाकर बोलना इस वार्ता में। कुछ हिंदी, लेकिन प्राइम लैंग्वेज जो महत्वपूर्ण लैंग्वेज रहेगी इंग्लिश। और जीवन के बारे में लाइफ, अभियंता, इंजीनियर्स, क्वालिटी, गुणवत्ता, और रेड एंड सिल्वर बुक्स फॉर फिडिक, सेफ्टी एंड ऑल डिज़ाइंस, कंस्ट्रक्शन, मेथड्स, कॉन्ट्रैक्टिंग, एटसेट्रा एटसेट्रा। Communication and coordination, important part. This talk, as usual, is very important, and these are certifications, as you can say. My email ID is, that is important here, suraj_engineer, engineer @yahoo.co.uk. Again I say suraj_engineer@yahoo.co.uk. अगर आपको कोई क्वेश्चन करना है, मैसेज भेजना है, कुछ पूछना है इस वार्ता के बारे में, या सिविल इंजीनियरिंग कंस्ट्रक्शन के बारे में, या सिविल इंजीनियरिंग डिज़ाइन के बारे में, तो आप इस ईमेल आईडी पर आप मुझे मैसेज कर सकते हैं, suraj_engineer@yahoo.co.uk। और एक और मेल है जो इसमें नहीं लिखी है, वो भी मैं बोल देता हूँ आपको, अगर आप चाहें तो उसका प्रयोग कर सकते हैं। वो है सूरज सिंह PE, SURAJ सूरज SINGH सिंह PE @gmail.com। और ये है मेरा अभी करंट सर्टिफिकेट की डिक्लेरेशन। चार्टर्ड इंजीनियर हूँ मैं भारत का। FI मेरी कॉर्पोरेट मेंबरशिप की टाइटल है, फेलो ऑफ इंस्टीट्यूशन ऑफ इंजीनियर्स। ये आप लोग वो देख रहे हैं, और ये मेरा सिंपल सा फ़ोटो। और मैं अभी इंटरनेशनल प्रोफेशनल इंजीनियर्स भारत के रोल पर हूँ। रजिस्ट्रेशन जो वैलिड है 4 साल के लिए और 5 साल की होती है। इट्स वैलिड फॉर 5 years, एंड एवरी 5 years if you want to continue, one has to apply for renewal, and renewal depends on what performance has been done in last 5 years, how much one has learned. Have you learned something or you have not learned something? It depends upon that. आपने पिछले 5 वर्षों में व्यवसाय में क्या सीखा और कितना अपने आप को आगे बढ़ाया, कितना आपने लोगों को सिखाया, क्या आपने समझा, हर विषय के बारे में, कैसे काम होता है, काम में से क्या होता है, जो भी आप सीख सकते हैं। अपने देश में क्या हो रहा है, विदेशों में क्या हो रहा है, प्रोजेक्ट पे क्या हो रहा है, वो सब उसमें दिखाना पड़ता है। वो चाहे प्रोफेशनल इंजीनियर की रजिस्ट्रेशन का रिन्यूअल हो या इंटरनेशनल प्रोफेशनल इंजीनियर की रजिस्ट्रेशन का रिन्यूअल हो। ये इंटरनेशनल सिस्टम है जिसको हम कहते हैं IPEA, इंटरनेशनल प्रोफेशनल इंजीनियर्स एग्रीमेंट, जिसमें बड़े बड़े देश उपस्थित हैं, उसके सदस्य हैं। मैनी मेजर कंट्रीज ऑफ वर्ल्ड लाइक UK, लाइक USA, Japan, South Africa, England, likewise you can say, and Bharat, India is also one of them. I think currently there are 15 members in that agreement, and that is International Professional Engineers Agreement, IPEA. Previously it was called Engineers Mobility Forum. ये आपकी इंफॉर्मेशन के लिए मैं बता रहा हूँ, ओनली फॉर इंफॉर्मेशन, व्हाट इज़ दैट, व्हाट डज इट मीन, एंड व्हाट इज़ चार्टर्ड इंजीनियर, Just for your information, according to law in this country, Bharat, India, according to this Royal Charter of Institution of Engineers India, which is constitutional provision, actually it's a constitution. Charter means constitution, for your information. Just like we say Constitution of India, भारत का संविधान, एक्चुअली दैट इज चार्टर ऑफ इंडिया, भारत का चार्टर जो भारत के लोगों ने बनाया है, भारत के लोगों ने बनाया। और यही चार्टर जो इंस्टीट्यूशन ऑफ इंजीनियर्स का है, ये उस समय 1935 में, एट दैट टाइम इन 1935 इट वाज ग्रांटेड टू दिस association that was called Institution of Engineers India. At that time it was registered in 1920 under Indian Companies Act, and later on in 1935 it was granted its royal charter by King George V, and that was law at that time. And under that law charter was granted, and that charter is original one, it's not delegated one. And you know, it is direct responsibility, it is direct authority and privilege and prerogative of king. In those days it was that if it wanted for societies who are advanced one, who are independent one in financial matters, and who have more than 500 or 5,000 I think members, those societies could be given such privilege that is above statute. It is more valuable than Parliament Act. So it is that, just for your information. I am explaining what is this because you may ask this question. इससे पहले कि आप ये क्वेश्चन करें तो मैं आपको ये बता रहा हूँ. Well, let's go to other one, and that is this certificate which I am talking to you. So this is that certificate, and it is valid for, its date is given up to 30th September 2025. And in writing, after name we can write int PE India, or if you are in America, int PE USA, or if you are in England, EP like that. And it is Chartered Engineer India certificate, that is what I said, FIE or MIE or AMIE. All these three membership categories can use this title, Chartered Engineer India. And then it is membership, fellow membership here, that's a fellow, FELLO. And here is file which I am going to discuss with you because I just made some amendment to this yesterday, and this is regarding communication and coordination, and title of this file is Quality Systems. I am going to close this certificate now, so I have explained to you, purpose is over. Now I am just now trying to explain to you what is quality, what you understand by quality, and what do you understand by safety, health and environment. It's very important to understand this in reality. I have started this file, I think I started on 5th, I think 15th May I started this file, and maybe some dates I forgot, but you can see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, about 18 or more than 18 amendments have been made to this file. And now it's for, I just want to stress, means so what is quality. मैं जरा बताना चाहता हूँ, जोर देना चाहता हूँ गुणवत्ता पे, कि गुणवत्ता आखिर है क्या, हम क्यों गुणवत्ता की बात कर रहे हैं. It's really very important that we should be smart enough. As a citizen of this country, as a citizen of this world, we should respect quality, we respect safety, and we cannot do that. If we cannot do that, we can say we have no smartness in life. These days we call it smart, this is smart, that is smart. And I would say, first of all, everybody has to be smart. And that smartness means one should have quality character, quality profile, not fabricated profile or fake profile. Quality profile means reality of life, because life itself is reality. जीवन एक वास्तविकता है, जीवन एक क्वालिटी का होना चाहिए. क्वालिटी का मतलब फैसिलिटीज से नहीं है, क्वालिटी का मतलब आप किस तरह से सोचते हैं और कि आपका काम करने का तरीका है, काम करने का आपका मेथड है. और इंजीनियरिंग खास तौर से अभियांत्रिकी तो वो दुनिया है जिसमें माइंड लगाना पड़ता है, माइंड ही चलता है, और जहाँ माइंड नहीं चलता उसको अभियांत्रिकी नहीं कर सकते. सो इसमें हमने क्या कहा है, क्वालिटी प्लस SHE प्लस इंजीनियरिंग अप्रोच रिडिफाइंड. क्वालिटी जो एक बहुत बड़ा इशू है, जिसके बिना कुछ होता ही नहीं है, समझने की बात है. वी कैन नॉट डू एनीथिंग विदाउट इंक्लूडिंग क्वालिटी इन टू आवर लाइफ, इन टू आवर वर्क, इन टू आवर सिस्टम, इन टू आवर पर्सनल इशूज़. Quality of individuality, quality in society, and before that, quality in family, quality in your country, quality in your profession, quality in your social dealings, quality in your professional dealings. And how do you think quality is for you and you are for quality? And quality doesn't mean only testing. Quality means every part of life. It's every integration part or unit of system. System itself is quality, and quality makes a system, and systems gives improvement to quality. And every part of system, every activity of system, every life requirement and life doing it relates to quality. It's up to you how to define that. आप गुणवत्ता को कैसे परिभाषित करते हैं, या आपको देखना है. कोई बाहर का आके परिभाषित नहीं करेगा. हाँ, गाइड अवश्य कर सकता है. आपको अपने दिमाग से, अपने मस्तिष्क से सोचना होगा कि सबसे बढ़िया तरीका क्या है. सबसे बढ़िया तरीके का मतलब जिसमें कम से कम खर्चा हो, कम से कम नुकसान हो. नेचुरल रिसोर्सेज का, प्राकृतिक सूत्र को, प्राकृतिक आप क्या कह सकते हैं, रिसोर्सेज जो हमको प्राकृतिक धन हासिल है, जैसे मटेरियल हासिल है, वो कम से कम इस्तेमाल हो, ज़्यादा से ज़्यादा समय के लिए इस्तेमाल हो, ड्यूरेबिलिटी उसमें हो. वही क्वालिटी का मतलब होता है. क्वालिटी का मतलब सेफ है, क्वालिटी का मतलब यूजेबल है, क्वालिटी का मतलब लंबे समय के लिए है, क्वालिटी का मतलब एफोर्डेबल है, और क्वालिटी का मतलब गंद ना फैलाए, पॉल्यूशन ना करे, और सही तरीके से आगे चले. कम से कम हमको नुकसान हो, हमारी हेल्थ सही रहे, हमारा हम सब कुछ वातावरण को सही रखें. वी हैव टू केयर अबाउट सेफ्टी, वी हैव टू केयर अबाउट हेल्थ, एंड वी हैव टू केयर अबाउट एनवायरनमेंट. एंड फॉर दैट वी हैव टू केयर अबाउट इंडिविजुअलिटी, एंड इंडिविजुअल मस्ट बी ट्रेन्ड अकॉर्डिंगली. एंड इंडिविजुअलिटी मीन्स सिस्टम. Every person makes a system, every person is a part of system. So we have to understand quality, safety, health, environment, and engineering is a world where nothing can be done without engineering, and engineering makes a life, and life gives improvement to engineering. And engineering is continuous development. It's not simply that today we do this fix one. No, nothing is fixed in engineering. Engineering is hands of individuals, and individuals means engineers. Engineering doesn't mean that you are a qualified engineer, you are educated engineer, you are only engineer. Every work is engineering which is useful. Every technology that gives work or that works upon is engineering. Every useful product is engineering product, and in fact we can say it's a common word as well as its application word. Both are there. Engineering can be used as verb, it can be used as noun, it can be used in procedure. And it can be used in education, it can be used in profession, it can be used where? Means engineer is something very common. It tells you, it indicates to you that engineer means a person who uses mind, who applies mind. En means inside, and gen means engine means you can say intelligent work, genius work, a work, that genius instrument, that instrument is mind. It asks you to do, that is engineering, means use of mind, intellectual power is engineering. And it also is science, and it's also every profession where application is done, not second stage, first stage application is done. Engineering is a profession where first, or you can say original work is done, and that is just we considered this way. So I say, what is important in engineering? In engineering is important, first of all, we have to understand about communication, coordination. सब समझने से पहले हमको संचार व्यवस्था और संतुलन कैसे रखा जाए, इसको समझना होगा. संचार तथा संतुलन अत्यंत आवश्यक है सही गुणवत्ता पाने के लिए, सही क्वालिटी पाने के लिए. Communication and coordination, most significant disciplines or subjects or topics. कुछ हिंदी में मैंने जैसे कहा, समथिंग इन हिंदी एंड समथिंग इन इंग्लिश. लिखित में दस्तावेज आवश्यक है, राइटिंग में दस्तावेज आवश्यक है. मोबाइल से लंबी बातचीत का अधिक उपयोग सही नहीं. मेडिकल टॉक है, दूसरी बात है, बहुत सारे रीजंस हैं. दूसरों को भी बातचीत का अवसर मिलना चाहिए. रिटन डॉक्यूमेंट इज ए मस्ट फॉर रेफरेंस. जस्ट मोबाइल यूज डिपेंडेंस इज नॉट सफिशिएंट, and long talks must be avoided. If you go further, this is not instruction, this is just A deliberation means written document is a must for reference. You cannot ignore it. Just mobile use dependence is not sufficient and long talks must be avoided. I think this is quality thinking because just talking and talking means nothing. So that others should not wait for respective talking turn. If you are a busy person, if you work in a profession, there will be many other people who must be waiting to talk to you, and if you talk for long to one person, then you miss their time. You have to think that way. Talking to point and talking to in a short way is best. If you want to give explanation, you can give explanation, or you can issue some written document, or you can do something like that, so that everything is preserved. गुणवत्ता, हादसों से सुरक्षा, शक्ति उपयोग, क्वालिटी एसएच एर्गोनॉमिक्स, कॉन्ट्रैक्ट्स एंड प्रोडक्ट्स। गुणवत्ता बिना सब कर्म बेकार। अगर आप क्वालिटी नहीं कर सकते, क्वालिटी नहीं दे सकते और फिर आप काम करते हैं तो वो काम जिसमें क्वालिटी नहीं है वो कर्म बेकार होता है। उत्तरदायित्व अभियंता का गुणवत्ता प्राप्त करने हेतु अभियंताओं का इंजीनियरों की जिम्मेदारी है, उनका रोल है क्वालिटी को प्राप्त करने के लिए। एक खास रोल, स्पेसिफिक रोल है उनका। उसके बिना अभियंता अभियंता नहीं, इंजीनियर इंजीनियर नहीं। क्वालिटी इन कंस्ट्रक्शन, quality in production, manufacturing, quality in service, quality in education, quality in society and individual, quality in communication and coordination. Quality required everywhere, in every activity in life and in engineering. And life is engineering based, which means that engineering is domain of super life and profession like medical is domain of super profession. गुणवत्ता निर्माण में, जीवन में, सेवाओं में, हर कार्य में, शिक्षा में, समाज में, व्यक्ति में उतने ही आवश्यक है जितना सांसों में गुणवत्ता हर काम में आवश्यक, उतने ही आवश्यक है जितना सांसों में गुणवत्ता हर काम में आवश्यक। सुरक्षा बिना सब कर्म बेकार व्यर्थ। उत्पादन हो या उद्योग या निर्माण, सेफ्टी, हेल्थ, एनवायरनमेंट रिक्वायर्ड एवरीवेयर ड्यूरिंग मैन्युफैक्चरिंग एंड प्रोसेसिंग, इन कंस्ट्रक्शन, ऑल एक्टिविटीज इन कंस्ट्रक्शन एंड ऑल्सो ड्यूरिंग यूज ऑफ प्रोडक्ट्स एंड वट एवर सर्विसेज, वेयर इज सब यू गो। Ergonomics is a science that requires everyone about how to use available energies for doing whatever work activities in best possible safe manner so that involved worker is least impacted upon by adverse action imposed upon by such activities. These requirements are certainly must. No way to respond to these no. Must ask yourself no way out, and without good quality compliance application, good SHE compliance applications, nothing can move in right direction. SHE is very first consideration on each and every activity, on each and every project, and on each and every operation, all to be supported by applications of principles of ergonomics. SHE claims that safety first. If safety is conducted, what happens? And if safety is ignored, what happens? Certainly breach of contract provisions. No one has got any right to give undue pains to others. No one has got any right to condemn quality requirements because quality is also paid for when product is purchased. सुरक्षा है तो दर्द नहीं, सुरक्षा नहीं तो दर्द ही दर्द। No safety, no pain, and no safety, no pain. Quality, no pain, and no quality, only pain. गुणवत्ता की आवश्यकता हर कार्य में। गुणवत्ता अभियंताओं के हाथ में, गुणवत्ता अभियंताओं के हाथ में तथा उन्हें इसको लागू करना होगा। क्वालिटी हैज़ टू बी कंप्लाइड विद डिफाइंड, स्पेसिफाइड, स्टेटेड रिक्वायरमेंट्स विद इन एम्बिट ऑफ वर्क डिजाइन, वैलिड स्पेसिफिकेशंस। Quality ranges in elaborations depending on indicative descriptions, and there exists no unlimited scope of quality criteria to be carried out. गुणवत्ता नहीं तो भविष्य नहीं. गंदा विकास चोरों द्वारा. गंदा विकास होगा चोरों द्वारा, डकैतों द्वारा. क्या अभियंता गलत लोगों के हाथ का खिलौना होंगे? No future if no quality persists, and its specified requirements must be met in all respects. No excuse is admissible for quality failure. गुणवत्ता आवश्यक. Quality is a must and a must. अभियंताओं को समझना होगा गुणवत्ता आवश्यक. Engineers must realize quality facts. In particular, civil engineers have to change quality aspects of society, or else quality cannot exist. सिविल अभियंता वर्ग काफ़ी उत्तरदायी. सिविल अभियंता वर्ग काफ़ी उत्तरदायी. बाकी दूसरे अभियंता भी उतने ही उत्तरदायी. Engineer then becomes incapable, which means that engineering and life due to it cannot at all exist. Systems quality to be devised and achieved. Broken system means broken life linked to broken system. Professional individuals' working capacity quality to be amended from time to time, and one must be forced to amend its quality for obtaining reliability. By additional learning, due teaching, and by additional knowledge dissemination, relevant element or product defined quality to be achieved. Individuals required attitude quality to be streamlined. Individuals dedication to work to be applied on actions. जो काम करना है, कैसे करना है, ये आपको डिफाइन स्वयं करना है, कोई दूसरा डिफाइन नहीं करेगा. आपका मतलब, आप कॉम्पिटेंसी की मैं बात कर रहा हूँ, आपकी क्षमता की बात कर रहा हूँ. अगर आपके अधिकार हैं कि आपने क्या कराना है, आप इंजीनियर हैं, तो आपको डिफाइन करना है पहले डिज़ाइनर की हैसियत से, स्पेसिफायर की हैसियत से, ये काम ऐसा होना चाहिए. उसके बाद वो होता है तो ठीक है, क्वालिटी मानी जा सकती है. और उसके बाद अगर ऐसा नहीं होता है तो क्वालिटी जो डिफाइन की गई थी, परिभाषित की गई थी, उसको लागू नहीं किया गया. ये बात समझनी होगी. क्वालिटी अपने आप डिफाइन नहीं होती है. आपको कितना उस पर खर्चा करना है ये देखा जाता है, और कितना काम हमें लेना है इससे वो भी देखा जाता है. इसलिए क्वालिटी को डिफाइन करना और क्वालिटी को लागू करना दोनों आपके हाथों में है. वर्क कमिटमेंट टू बी मेड एंड फुलफिल फॉर डिलीवरी. जो काम करना है, जो कहा गया है, जो माना गया है कि ये करना है, उसको करना है. All other parameters to deal with per quality requirements. Designs of structures and others must be made decisive, safe, qualitative, and qualitatively must be reliable for prosecution as well as for long-term performance. Contracts must be explicitly clear and competent with having consistency pertinent quality issues. जो भी हम डिज़ाइन करें किसी भी ढांचे का, किसी भी स्ट्रक्चर का या दूसरी चीज़ों का, उनको सही फैसला होना चाहिए, सेफ होना चाहिए, क्वालिटी का होना चाहिए, क्वांटिटी का होना चाहिए, रिलायबिलिटी होनी चाहिए काम करने के तरीके में, काम करने में. और देखना चाहिए कि कितना लंबे समय तक ये काम चलना है, कितना लंबे समय तक इस स्ट्रक्चर का यूज़ होना है, और वो बात माइंड में रखनी चाहिए, मस्तिष्क में. उसी हिसाब से डिज़ाइन होना चाहिए और उसका काम होना चाहिए, परफॉर्मेंस होनी चाहिए. जो भी संविदा हम करते हैं, जो भी आप कह सकते हैं कॉन्ट्रैक्ट हम करते हैं, एग्रीमेंट हम करते हैं, बिल्कुल साफ़ होना चाहिए क्वालिटी के बारे में, कॉम्पिटेंसी के बारे में, और ये किस तरह का कॉन्ट्रैक्ट हो, वो क्या क्वालिटी उससे मिलनी ही चाहिए, ऐसे प्रोविजंस उसमें होने चाहिए. All stages designs being significant, but mere design does not alone suffice if construction and development are not affected to specified marks required or defined. Quality requirement cannot be allowed to be ignored. आप कंस्ट्रक्शन कैसी होगी, डिज़ाइन के ऊपर डिपेंड करता है, और उसमें कोई आप कह सकते हैं जो भी हम डिज़ाइन करते हैं वो ऐसा होना चाहिए, बिल्कुल सफिशिएंट हो, और उसमें कंस्ट्रक्शन को मजबूर कर दिया जाए कि आपको ऐसा काम करना होगा. उसमें पूरी डायरेक्शन होनी चाहिए, पूरी क्वालिटी होनी चाहिए, पूरी डिटेल होनी चाहिए कि बार बार कोई आपसे पूछे नहीं, थक ना जाए कि क्या डिज़ाइन बनाया है, समझ नहीं आ रहा है, कैसे डिज़ाइनर्स हैं, इसलिए अपने आप हम अपने कर देते हैं, देखा जाएगा. ऐसा नहीं होना चाहिए. ऐसा कल्चर नहीं डेवलप करना चाहिए. डिज़ाइनर्स को साइड पर सोचना चाहिए जब वो काम करते हैं डिज़ाइन का, कि हम इसको, अगर हम काम करें तो हमें क्या आवश्यकता पड़ेगी, ये सोचना चाहिए. कंस्ट्रक्शन बेस्ड ऑन रीजनेबल कोऑर्डिनेटेड कॉन्स्टेबल क्वालिटी डिज़ाइंस एंड सेफ्टी. Contracts must be clear in all approaches. All activities must be taken care of, but it doesn't happen. Reasons being lethargy in attitude and undue strains in minds. Why should sites suffer? Because of deficiency of design. Inefficiency of work conduct means मेरे ख्याल से कॉन्टेक्ट में साफ साफ होना चाहिए, क्लियर अप्रोच होना चाहिए, सब एक्टिविटीज़ क्लियर होनी चाहिए, केयर करनी चाहिए, लेकिन ऐसा होता नहीं है। इसके पीछे सुस्तापन, आलसीपन, कंसंट्रेशन का ना होना, ज़बरदस्ती माइंड में ख़राब होना, कुछ स्ट्रेस होना, इसकी वजह से साइट क्यों सफ़र करे, कार्यस्थल क्यों सफ़र करे। डिज़ाइन में अगर कमी है तो उसको ठीक कीजिए, वर्क कंडक्ट बनाइए, और अकाउंटेबिलिटी फिक्स होनी चाहिए डिज़ाइन की भी, कंस्ट्रक्शन की भी, कि कंस्ट्रक्शन ख़राब क्यों हो रही है, कहीं डिज़ाइन की वजह से तो नहीं, और ये सब सोचना होगा। Design accountability must be fixed if accountability on constructed product or element is required. Design and construction qualities are complementary to each other, and without integrated coordination, activities worked upon shall result in lesser quality results. डिज़ाइन जैसा है, कंस्ट्रक्शन जैसे दोनों का रिलेशन है, क्योंकि डिज़ाइन के बिना कंस्ट्रक्शन नहीं और कंस्ट्रक्शन के बिना डिज़ाइन की वैल्यू नहीं। दोनों एक दूसरे के पूरक हैं, नहीं तो काम होगा ही नहीं, होगा तो सही नहीं होगा। इंटेग्रेट दोनों को करना पड़ेगा, एक साथ दोनों को चलना पड़ेगा। और अगर काम ऐसा नहीं हुआ, क्वालिटी को नहीं स्थान दिया गया, तो रिज़ल्ट अच्छे नहीं होंगे। और उसके लिए आवश्यक एक समझना, मेथड स्टेटमेंट बनाना, काम कैसे किया जाए, पूरी डिटेल समझना, माइंड में रखना, लिख के देना। सबको पता होना चाहिए कि हमें क्या करना है। बहुत सारे तरीके होते हैं काम करने के, इसका मतलब ये नहीं है कि आप एक आदमी कोई तरीका इस्तेमाल करेगा, दूसरा आदमी कोई तरीका इस्तेमाल करेगा, नहीं, ऐसा नहीं। Construction method statements must for works implementation and therefore must be charted out professionally. No concession can be allowed on this activity. Method statement जो एक तरीका है एक सिस्टम बनाने का, हर एक्टिविटी का, पूरे प्रोजेक्ट का। मेथड स्टेटमेंट को, या आप कह सकते हैं काम करने के तरीके को, हर एक्टिविटी की, हर आइटम की एक ज़रूरत है लिखने की, समझने की। एक एक्सपीरियंस्ड आदमी के द्वारा इसने काम किए हों और उसको तरीके से लिखना, तरीके से दिखना, उसको पास करना, उसको इम्प्लीमेंट करना, ये सब चीज़ें हैं जो ज़रूरी हैं। और अगर ऐसा नहीं करते तो हम अपने हिसाब से काम कर देंगे, हो सकता है क्वालिटी मिस हो जाए, कंट्रोल ना रहे उस प्रोजेक्ट पे, उस एक्टिविटी पे। मेथड स्टेटमेंट और वर्क प्रोसीजर फॉर एवरी एक्टिविटी इज़ अ मस्ट, एंड इट शुड टेल फॉर्मली अबाउट व्हाट इज़ टू बी डन on works, and that must be done for quality realization, or else there can be no real control on works and therefore on projects. Expression of specific details in convenient format for work performance and define elaborate performance, or else can say activity, or else no work can be carried out in defined and designed sequence, and because of that output suffers, resulting in bad standards of work. मेथड का तरीका नहीं, हम कैसे काम किया जाए, तरीका नहीं, कोई कुछ भी करेगा और से हम कह सकते हैं बैड स्टैंडर्ड वर्क होगा, सब स्टैंडर्ड वर्क होगा। इसलिए मेथड स्टेटमेंट मस्ट बी मेड नेसेसरी फॉर एक्टिविटीज इम्प्लीमेंटेशन, और एल्स इसलिए आवश्यकता है कि मेथड समझा जाए, काम करने से पहले बताया जाए, लिखा जाए, और जो एक तरीका है वो अपनाया जाए। डाइवर्स वेज कैन बी अडॉप्टेड बाई साइट टीम, वो उस अवॉइड करना चाहिए, उसको अपने हिसाब से काम कहीं नहीं करना देना चाहिए, जो आपको फैसला करें सब मिलके, जो भी उसके लिए उत्तरदायी हैं, वो चाहे ठेकेदार का आदमी हो या कंसल्टेंट का आदमी हो या किसी का भी हो। फॉरगेटिंग नेसेसरी कम्युनिकेशन बेस्ड कोऑर्डिनेशन approaches and consequences would remain result without achieving any level of uniformity and consistency. इसलिए कोऑर्डिनेशन, कम्युनिकेशन बहुत ज़रूरी है। और वही हैं, और आप कह सकते हैं सिंथेसिस, सोच तथा एकाग्रता अत्यंत आवश्यक, सोच तथा एकाग्रता अत्यंत आवश्यक, थिंकिंग एंड कंसंट्रेशन सर्टेन पावर्स। थिंकिंग बेस्ड कंटेम्पलेशन and must be achieved. Designs and prosecution works applications must be affected. अभियांत्रिकी याद रखिए, इंजीनियरिंग। Non-conformance means engineer, अभियंता is either careless, लापरवाह, और ignorant, अनजान, और इनकम्पिटेंट, सक्षम नहीं, और फालतू, redundant। ये सब बताया हुआ। संचार तथा संतुलन, अत्यंत आवश्यक सही गुणवत्ता पाने के लिए कम्युनिकेशन एंड कोऑर्डिनेशन मस्ट मोस्ट सिग्निफिकेंट डिसिप्लिन सब्जेक्ट्स एंड वी कैन से गुणवत्ता निर्माण में, जीवन में, सेवाओं में, हर कार्य में, शिक्षा में, समाज में, व्यक्ति में उतनी ही आवश्यक है जितना सांसों में, लिखित में दस्तावेज आवश्यक है। मोबाइल से लंबी बातचीत का अधिक उपयोग सही नहीं, दूसरों को भी बातचीत का अवसर मिलना चाहिए। कर्म, ये एक तरह का तरीका था आपको समझाने के लिए कि हमें क्या करना चाहिए, क्या नहीं करना चाहिए आगे बढ़ने के लिए। बाकी फैसला आपने करना है कि कैसे आगे बढ़ा जाए, क्या किया जाए। अभी मैं फाइल खोलना चाहता हूँ, देखते हैं कौन सी फाइल सामने आती है अभी। और just a minute, it's processing and coming, and this is now we have here, this is act। बात हम कर रहे थे आर्बिट्रेशन की। आर्बिट्रेशन का मतलब मध्यस्थता है। डिस्प्यूट अगर हो जाते हैं कॉन्ट्रैक्ट्स पे, इफ़ यू हैव डिस्प्यूट्स ऑन कॉन्ट्रैक्ट ड्यू टू वट एवर रीज़न, देन आर्बिट्रेशन इज़ ए प्रोसीजर ऑल अराउंड वर्ल्ड। पूरे विश्व में आर्बिट्रेशन चलता है कॉन्ट्रैक्ट्स पे, क्योंकि झगड़े तो होते ही रहेंगे। कॉन्ट्रैक्ट लंबे चौड़े होते हैं, काम भी लंबे चौड़े होते हैं। कॉन्ट्रैक्ट्स लंबे समय तक के लिए होते हैं। एवरी कॉन्ट्रैक्ट इज़ फॉर लॉन्ग अंटिल प्रोजेक्ट इज़ ओवर। कॉन्ट्रैक्ट इज़ वैलिड एंड वी हैव टू अंडरस्टैंड दिस पॉइंट। आर्बिट्रेशन या कोर्ट फ़र्क कुछ नहीं है। फ़र्क इतना है कि कोर्ट परमानेंट होते हैं और आर्बिट्रेशन एक स्पेसिफिक टाइम के लिए, स्पेसिफिक काम के लिए, और पूरे काम के लिए भी नहीं, कुछ कुछ काम के लिए होती है। तो ये बात भी हमें बात कर रहे थे कॉन्सुलेशन की हम बात कर रहे थे। और जहाँ तक मुझे याद है हम कहाँ थे, हम शायद, खैर, I was explaining to you about arbitration. Arbitration is a legal procedure, it's statutory procedure, it's applicable all over the world. Every country has arbitration laws, arbitration statute, and contracts, particularly construction contracts or many other classes of contracts cannot move without arbitration, because everybody should not go to court to waste time of court, because court is general court. Court is general, it's you can say whatever it is, sessions court or high court, these are general courts of ordinary jurisdiction, you can say. These are not specialized court, and arbitration is a kind of specialization court where contracts are important and engineering world is also important. There are so many issues that are involved from engineering viewpoint. I've explained, I'm just particularly involved in, and because I'm a civil engineer and I know contracts, I know technology, I know how work is done, and like me, everybody knows. Every civil engineer or other engineers, they know how work is done, how production is done, how works are carried out, way with which it is carried out, and there can be dispute about whatever issue. It's not necessary claims, there can be other reasons. Procedures can be questioned, methods can be questioned, and quality can be questioned. You can say important point is quality. If dispute arises because of quality, this becomes an issue. It's not only tests can be done, means procedure or whatever we got, or there can be dispute of anything, whatever. We have to understand that point, in which some specialist is involved or required to check and find out solution. Engineer is always a specialist. Contractor is also a specialist in construction. We cannot ignore this fact. हम इस बात को नहीं भूल सकते कि चाहे वो ठेकेदार हों या वो इंजीनियर अभियंता हों, दोनों ही अपने अपने काम में विशेषज्ञ हैं। हम लोग कॉन्ट्रैक्टर को गिरी हुई नज़रों से देखते हैं कई बार हमारे देश में, वो ठीक बात नहीं है, क्योंकि कॉन्ट्रैक्टर अपने काम के लिए है, वो भी एक तरह का इंजीनियर ही है, जिसने इंजीनियर का काम करके देना है और इंजीनियर इसको अप्रूव करना है। You cannot underestimate, because contractor itself is a profession based on specialization. And if in itself contractor owner is not specialized, one has to employ specialized professionals who work in that profession, who work in that field, and who have long experience in contracting and working. So it may be designs, they are a specialist. It may be engineering supervisors, they are specialists. Or it may be contractor who is a specialist. An employer uses services of all. जो भी मालिक होता है, स्वामी होता है किसी भी प्रोजेक्ट का, उसने इन सभी की सेवाओं को लेना होता है. वो डिज़ाइनर की सेवा हो, वो सुपरवाइज़र की सेवा हो, वो ठेकेदार की सेवा हो, ये सब प्रोफेशनल्स आते हैं. कॉन्ट्रैक्टिंग काम इतना आसान नहीं है. ठीक है, हेरा फेरी लोग करते हैं, मैं उसकी बात नहीं करूँगा. मैं सिर्फ बात करूँगा क्वांटिटी की, क्वालिटी की, टाइम की. क्वालिटी के बिना क्वांटिटी बेकार है और दोनों टाइम खराब करते हैं. देयर इज़ नो मीनिंग ऑफ क्वांटिटी if quality doesn't exist, and quality plus quantity impact upon time. You can waste time very easily, and time wastage is no solution. Saving of time is important, right use of time is important, and whatever we do should be according to our requirements, should be according to provisions in contract, according to specifications, and that is what is required. Time cannot be killed, time cannot be destroyed, because if we try to destroy time, time shall destroy us. अगर हम टाइम को ख़राब करना चाहें तो टाइम तो ख़राब नहीं होगा, हाँ हम ज़रूर ख़राब हो जाएंगे, हमारे काम ज़रूर ख़राब हो जाएंगे. इसी तरह से अगर हम क्वालिटी को ख़राब करना चाहें, क्वालिटी तो ख़राब होगी ही होगी, हम भी ख़राब हो जाएंगे. देयर डबल लॉस. एक तो हम गलत काम सीख रहे हैं, समय बर्बाद कर रहे हैं, प्राकृतिक संपदा को खराब कर रहे हैं, क्योंकि कोई भी मटेरियल प्राकृतिक ही होता है एक तरह से, सीधा या ना सीधा. एवरी मटेरियल कम्स फ्रॉम नेचुरल रिसोर्सेस, एंड इफ यू स्पॉइल क्वालिटी मीन्स वी स्पॉइल दैट मटेरियल विच नेचर हैज एंडाउड अस ब्लेसिंग्स. जो प्रकृति हमको आशीर्वाद के रूप में दिया है, हम उस मटेरियल को ख़राब नहीं कर सकते. इसीलिए ये डिस्प्यूट्स तो चलेंगे, क्योंकि समझ की बात है. हमने क्या बनाया, क्या डिज़ाइन किया, क्या उसको कहा कि ऐसे काम होना चाहिए, लेकिन हम नहीं कर पा रहे हैं. तो ये रीज़न भी अपने आप में बहुत इम्पोर्टेंट है. आर्बिट्रेशन हम क्यों जाते हैं? हम इसीलिए जाते हैं कि कहीं ना कहीं प्रॉब्लम होती है. जो दोनों पार्टी, बोथ पार्टीज, कॉन्ट्रैक्टर एंड ऑनर, दे आर अनेबल टू सॉल्व इट ड्यू टू वट एवर रीज़न, technical reason or other reasons, or ambiguities in conditions, whatever be, cost wise, quality wise, system wise, or extension of time wise, or defects notification period time. There are so many reasons, because there are so many conditions. It's not just one page contract or 2-page contract. Contracts there contain hundreds of clauses, and if you see general statements, general formats of FIDIC, that is valid for red, that is construction contract, or which is silver, that is EPC, this means design and construction contract. One likewise procurement, it includes engineering, it includes procurement, it includes construction. So engineering means design, and procurement means procure everything on that project. So we can say that it's very strong issue, strong talk about contracts, and contracts is not easy. Contracts are not easy. It needs some practical knowledge. Simply by going through books, we cannot say that we know contracts. Even if advocate or judges are there working all over the world, they get information through some other, and they cannot visualize what happens, why this has occurred. So they draw, maybe they extract or draw feedback from specialists. That's why, because of specialization involved, 95% specialization is involved in contracts. It may be supply contracts or it may be work contract, where complexities do arise. and there are various classes of specifications, and there are various types of designs, and various professional specifications, discipline wise or engineering wise. It becomes very specialized world, and contractor means a person who has to deal with every such requirement, every such provision. कॉन्ट्रैक्ट में जो भी प्रोविज़न है उसको समझना, उसको करके देना, ये कॉन्ट्रैक्टर की जिम्मेदारी है, उत्तरदायित्व है। अगर कॉन्ट्रैक्टर ऐसा नहीं करता तो कॉन्ट्रैक्टर सही काम नहीं कर रहा। कॉन्ट्रैक्टर को हमें दूसरे एंगल से देखना होगा। कॉन्ट्रैक्टर मीन्स हमारा काम करके देने वाला, और सही काम करके देने वाला, क्वालिटी से काम करके देने वाला, टाइम में काम करके देने वाला, और कॉस्ट के अंदर सही अच्छी तरह से खुद भी कमाए और हमारा काम भी चले। कमाने का मतलब ये नहीं कि वो बहुत कमाए, जो भी परमिसिबल है, जो हम काम करते हैं हम खर्च करते हैं, हमारे बेहद पे वो काम कर रहा है, वो खर्च कर रहा है, तो उसका भी हक बनता है, अधिकार बनता है। इसलिए जब झगड़े होते हैं आपस में, वो झगड़े इतने कॉम्प्लेक्स हो जाते हैं, दोज डिस्प्यूट्स विच अकर बिटवीन, विच एग्जिस्ट बिटवीन एम्प्लॉयर एंड कॉन्ट्रैक्टर फॉर वॉट एवर रीजन, those cannot be resolved directly by court, because court does not have that access or that in-depth studies of those subjects. And even advocates and lawyers, they are same as court, they don't have that access. They cannot visualize, they cannot realize what these disputes are and what was reason behind that. But that person who is expert in that profession very well can understand. If I am an engineer, I have a construction experience, I can understand why this happened, because site never works like commerce. It's technical work, it's engineering work, it's production work. We have to ignore many recording. We cannot write everything. We cannot get signature on every activity. We have to deal with very low profile educated people, but they know job. Similarly, we have to deal with middle class and all highest intelligent people. We have to deal with vendors who cannot be expected to be very highly qualified, and also those agents and dealers who do not know anything about technical work, but they know trading. So we have to deal with traders, we have to deal with agents, we have to deal with supplying agents, contracting agents, vendors, and we have to deal with all classes of workers, and we have to deal with equipment, and we have to deal with statutory bodies, public bodies. So it's a kind of miscellaneous communication and coordination issue. That's why in the beginning I started saying communication and coordination are very important parts in profession of contracting and engineering. Both are complementary. Engineers require something, define something, specify something that must be achieved, and job of engineer is to make sure that this has been achieved by contractor. And duty of contractor is to do according to what is specified, what's included, what's described, what's prescribed in contract. Whatever provisions have been included, those must be implemented with. And if some clash comes in, some disagreement comes in, then we have to refer this to first of all to an engineer who is responsible to solve it. First level of dispute resolution is the engineer itself. Then second level is, you can say, DAAB, which means Disputes Avoidance and Adjudication Board. And if that too fails, when the disputes are referred to after engineer's section or engineer's line, then you can say DAB. And even if there is dissatisfaction on DAB's decision, then we can say arbitration. Arbitration and conciliation are referred to. So we were talking about Arbitration and Conciliation Act 1996, that is Indian Act, and it has been amended 2 or 3 times, maybe 2000, 2015, 2018, and I think 2020 or 21. We were discussing about Act original first, because we have to understand what is that Act. And if we don't understand Act, we cannot understand what amendments mean. Because in beginning, it was optional, a kind of okay, arbitration was there, it was already existed, but In 96, it was a little amended because it has been there long back. If you go back in 40s, you'll find that there's a lot. But that was like, it was not mandatory. Now, in 96 means it was upgraded to level of court, which means whatever awards is made by arbitrator or tribunal is equivalent to tribunal, arbitration panel or group, or whatever you can say, arbitrator, one person or 3 person or whatever, it's called tribunal according to statute and according to constitution of this country, and therefore we can say that is powerful. Award issued by arbitration panel or tribunal has same power as award decreed by whatever court. It has same force. Court cannot set aside without logical reasons, and award can directly be enforced by law. There are 2 stages. First stage, if there is conciliation attempt and can be done, that is preferable. Otherwise, arbitrator would do its job. So let us say this is section 45 or what it was. I don't exactly remember where did we stop. Okay, settlement agreement we are talking about. So arbitration and conciliation settlement agreement. Let us repeat. When it appears to conciliator that there exist elements of settlement which may be acceptable to parties, that conciliator formulate terms of possible settlement and submit them to parties for their observations. After receiving observations of parties, conciliator may reformulate terms of a possible settlement in light of such observations. If parties reach agreement on settlement of dispute, they may drop and sign a written settlement agreement. If requested by parties, conciliator may assist parties in drawing up settlement agreement. When parties sign settlement agreement, it shall be final and binding on parties and persons claiming under them respectively. Conciliator shall authenticate settlement agreement and furnish a copy thereof to each other. कोशिश होती है आर्बिट्रेटर के द्वारा या कंसिलेटर के द्वारा कि किसी तरह से इनका पार्टीज़ का फैसला स्वयं ही करा दिया जाए, सजेस्ट किया जाए इनको, भाई आप फैसला कर लीजिए, क्यों टाइम बढ़ाते हैं, कुछ फ़ायदा नहीं है, और इस फैसले से आपको ये नुकसान नहीं होगा, इस फैसले से आपको ये नुकसान या फ़ायदा होगा। कन्विंस कर सकते हैं, समझा सकते हैं कि क्या फ़ायदा है। अगर ऐसा होता है तो अच्छी बात है। आप तैयार कर सकते हैं एक कंसिलेटर की हैसियत से क्या सेटलमेंट होनी चाहिए, और वो सब मानते हैं तो उसको बना के साइन करके ले लेना चाहिए। ऐसा हो सकता है, कोई बड़ी बात नहीं है, क्यों झगड़ा बढ़ाना, और बढ़ाना है तो फिर बढ़ाने का तो कोई अंत नहीं होता। और अगर ऐसा दोनों पार्टी मान लेती है तो कॉन्सुलेटर्स को ऑथराइज कर सकते हैं, ऑथेंटिकेट कर सकते हैं कि ऐसा हुआ, और वो भी एक तरह का अवार्ड ही होता है। नाउ 74 क्या कहता है, स्टेटस एंड इफेक्ट ऑफ सेटलमेंट एग्रीमेंट। Settlement agreement shall have same status and effect as if it is an arbitral award on agreed terms on substance of dispute rendered by an arbitral tribunal under section 30। मैं बता दिया आपको इसका वही मतलब है आर्बिट्रल अवार्ड का है। कॉन्फिडेंशियलिटी, कॉन्फिडेंशियलिटी आप जानते हैं सीक्रेसी क्या होती है, हम कोई बात डिस्क्लोज नहीं करना चाहिए। नॉट विद स्टैंडिंग एनीथिंग, नॉट विद स्टैंडिंग वॉट एवर contained in whatever other law, for time being in force, conciliator and parties shall keep confidential all matters relating to conciliation proceedings. Confidentiality shall extend also to settlement agreement except where its disclosure is necessary for purposes of implementation and enforcement. सीक्रेसी तो सीक्रेसी है, गुप्त रहना चाहिए जो भी फैसला किया गया है, किस कंडीशंस पे किया गया है, क्या उसमें इशू रखे गए हैं, चाहे कोई भी कानून कोई भी नियम कुछ भी कहता हो, लेकिन जो आप कर रहे हैं उस केस में उन पार्टीज़ के बीच में और कॉन्सिलेटर करा रहा है उसको गुप्त रखना आवश्यक है। लेकिन जहाँ ज़रूरत है, जहाँ नियमित ज़रूरत है कि इम्प्लीमेंटेशन की ज़रूरत है, कार्य करने की ज़रूरत है उस फैसले के ऊपर, और इन्फोर्समेंट की ज़रूरत है, वहाँ आपको डिस्क्लोजर करना चाहिए। उसके बाद टर्मिनेशन ऑफ कॉन्सिलेशन प्रोसीडिंग्स। Conciliation proceedings shall be terminated by signing of settlement agreement by parties on date of agreement, by a written declaration of conciliator after consultation with parties to effect that further efforts at conciliation are no longer justified on date of declaration, by a written declaration of parties addressed to conciliator to effect that conciliation proceedings are terminated on date of declaration, by a written declaration of a party to other party and conciliator if appointed to effect that conciliation proceedings are terminated on date of declaration. जब आपका साइन हो जाता है एग्रीमेंट दोनों पार्टीज द्वारा, उस दिन आप कह सकते हैं कि हमारी प्रोसीडिंग कॉन्सिलेशन की फैसला कराने की समाप्त हो गई, या एक रिटर्न डिक्लेरेशन कॉन्सिलेटर जो देता है पार्टीज से बात करने के बाद कि आगे की कार्रवाई आवश्यक नहीं है, उसी दिन डिक्लेरेशन वाले दिन को आप कह सकते हैं कि कॉन्सिलेशन प्रोसीडिंग कॉन्सिलेशन कार्रवाई फैसला कराने की कार्रवाई समाप्त हो गई। या पार्टीज लिख के दे दें कॉन्सिलेटर को उस तरीके को, उस फैसले को कि हम ये प्रोसीडिंग को समाप्त कर रहे हैं, उस लिखे हुए दिन से प्रोसीडिंग समाप्त हो जाती हैं। या एक पार्टी दूसरी पार्टी को लिख के दे दे और कॉन्सिलेटर को लिख के दे दे कि हमारी ये प्रोसीडिंग समाप्त हो रही हैं, वो समाप्त मानी जाएगी। Resort to arbitral or judicial proceedings. Parties shall not initiate during conciliation proceedings any arbitral or judicial proceedings in respect of dispute that is subject matter of conciliation proceedings, except that a party may initiate arbitral or judicial proceedings where in its opinion such proceedings are necessary for preserving his rights. जब भी ये प्रोसीडिंग चल रही है, जुडिशल प्रोसीडिंग, आर्बिट्रल प्रोसीडिंग चल रही हो, कॉन्सिलिएशन प्रोसीडिंग चल रही हो, किसी भी डिस्प्यूट के बारे में जो उसका सब्जेक्ट है, मैटर है, पार्टी दूसरी प्रोसीडिंग ना शुरू करे। पार्टी शैल नॉट इनिशिएट ड्यूरिंग कॉन्सिलिएशन प्रोसीडिंग्स आर्बिट्रल और जुडिशल प्रोसीडिंग्स इन रिस्पेक्ट ऑफ डिस्प्यूट ऑफ सब्जेक्ट मैटर। अगर ये चल रहा है डिस्प्यूट रेजोल्यूशन में तो उसको कहीं और ना चलाए। हाँ, अगर राइट्स अफेक्ट होते हैं तो अलग बात है। आर्बिट्रेशन कॉन्सिलेशन में कॉस्ट क्या है? अपॉन टर्मिनेशन ऑफ कॉन्सिलेशन प्रोसीडिंग्स, conciliator shall fix cost of conciliation and give written notice thereof to parties. जब ये समाप्त हो जाती है कॉन्सिलेशन प्रोसीडिंग्स, तो ये कॉन्सिलेशन कराने वाले कॉन्सिलेटर्स है जो भी मेंबर्स है पैनल के, वो कॉस्ट बताएंगे कि हमारी सेवाओं का इतना पैसा दिया जाए राइटिंग में दोनों पार्टीज़ को। और कॉस्ट मीन्स रीजनेबल कॉस्ट, जो कॉस्ट रीजनेबल है, खर्चा रीजनेबल है। फी एंड एक्सपेंसेस ऑफ कॉन्सिलेटर एंड विटनेसेस रिक्वेस्टेड बाय कॉन्सिलेटर विद कंसेंट ऑफ पार्टीज। जो भी फीस बनती है, खर्चे बनते हैं कॉन्सिलेटर के, गवाहों के, वो खर्चे तो देने होंगे पार्टीज के कंसेंट से। एक्सपर्ट एडवाइस रिक्वेस्टेड बाय कॉन्सिलेटर विद कंसेंट ऑफ पार्टीज, किसी भी विशेषज्ञ की सलाह ली गई हो, वो खर्चा भी। असिस्टेंस प्रोवाइडेड परसेंट टू सेक्शन 60, वट एवर असिस्टेंस इज देयर, एंड एक्सपेंसेस खर्चे, एक्सपेंसेस इनकर्ड इन कनेक्शन विद कॉन्सिलेशन प्रोसीडिंग्स एंड सेटलमेंट एग्रीमेंट, या जो भी खर्चा उसमें हुआ है, कॉस्ट शैल बी बॉर्न इक्वली बाय पार्टीज, दोनों पार्टी बराबर बराबर हक रखेंगी खर्चा करने का। And settle agreement provides for a different apportionment. All other expenses incurred by party shall be borne by that party. खर्चा बराबर दोनों पार्टी का। यदि कॉन्ट्रैक्ट में कुछ और प्रोविजन ऐसा है कि हम इतना करेंगे आप इतना करें तो अलग बात है। इसके बाद डिपॉजिट्स, जमा क्या करना है। कॉन्सिलेटर में डायरेक्ट each party to deposit in equal amount as an advance for cost referred to in that section 80 which expects will be incurred. जो एस्टिमेट होगा भी इतना खर्चा हो जाएगा तो कॉन्सिलेटर पूछ सकता है, कह सकता है पार्टीज को कि जमा किया जाए। और इसके अलावा भी कि जब कार्रवाई चल रही है तो और भी खर्चा जमा किया जा सकता है। ड्यूरिंग कोर्स ऑफ कंसोलेशन प्रोसीडिंग्स, कंसोलेटर में डायरेक्ट सप्लीमेंट्री डिपॉजिट्स in an equal amount from each party. अगर if required deposits are not paid in full by both parties within 30 days, consulator may suspend proceeding or may make a written declaration of termination of proceedings. The parties effective on date of declaration. अगर दोनों पार्टीज खर्चा जमा नहीं करा रही हैं 1 महीने के टाइम में, 30 दिन के टाइम में, काउंसलर चाहें तो प्रोसीडिंग को सस्पेंड कर सकते हैं, आगे डेट दे सकते हैं या उसको समाप्त कर सकते हैं। अपॉन टर्मिनेशन ऑफ कांसलेशन प्रोसीडिंग्स, काउंसलेटर shall render an accounting to parties of deposits received and shall return many unexpected balance to parties. अगर टर्मिनेट कर दिया तो हिसाब किताब दे के बाद ख़त्म किया जा सकते हैं। ये लीजिए आपका पैसा जमा था, वापस ले लीजिए इसको, या हमारा इतना खर्चा हो गया हम काट रहे हैं। रोल ऑफ काउंसलेटर इन अदर प्रोसीडिंग्स। Conciliator shall not act as an arbitrator. First of all, conciliator shall not act as an arbitrator or as a representative or counsel of party in whatever arbitral or any arbitral or judicial proceeding in respect of dispute that is subject of conciliation proceedings. Conciliator shall not be presented by parties as a witness in whatever any arbitral or judicial proceedings. जब कॉन्सुलेटर है उसका कोई रिलेशन नहीं होना चाहिए पार्टीज से, उनका रिप्रेजेंटेटिव नहीं होना चाहिए कोई भी प्रोसीडिंग में जो झगड़े से संबंधित हो, और ना वो गवाह बनना चाहिए किसी प्रोसीडिंग में। Admissibility of evidence in other proceedings. Parties shall not rely on or introduce as evidence in arbitral or judicial proceedings whether or not such proceedings relate to dispute that is subject of conciliation proceedings. Views expressed or suggestions made by other party in respect of possible settlement of dispute and admissions made by other party in course of conciliation proceedings, proposals made by counselor, fact that other party had indicated its willingness to accept a proposal for settlement made by counselor. ये जितने भी डिस्क्राइब किए गए हैं इनको रिलाई नहीं किया जाएगा, इनको एविडेंस नहीं माना जाएगा, नहीं दिया जाएगा दूसरे केसेस में। पावर ऑफ हाई कोर्ट टू मेक रूल्स। पावर ऑफ हाई कोर्ट टू मेक रूल्स, उच्च न्यायालय की अधिकार। If difficulties arise in giving effect to provisions of this act, central government may by order published in official gazette, make such provisions not inconsistent with provisions of this act as appear to it be necessary or expedient for removing difficulty, provided that no such order shall be made after expiry of period of 2 years from date of commencement of this act. Every order made under this section shall, as soon as may be after it is made, be laid before each house of parliament. There's a procedure, means nothing to every statute. हर कानून में कुछ ना कुछ लिखा होता है. Now, level of difficulties also, this is central law. If difficulty arises in giving effect to provisions of this act, central government may by order published in official gazette make such provisions not consistent with provisions of this act as appear to it to be necessary or expedient for removing difficulty, provided that no such order shall be made after expiry of a period of 2 years from date of. Okay, this is all same. Power to make rules also same. Power to make rules, I'm not interested in that. Repealing and saving is also. What was repealed in this? In this says, this arbitration, or you can say protocol and convention, Act 1937, Arbitration Protocol and Convention, Act 1937, Arbitration Act 1940, so it was in 1940 or 1937 you can say. In 1937 the Arbitration Protocol and Convention, in 1940, it's Arbitration Act, and Foreign Awards, that's Recognition and Enforcement Act 1961. These were repealed in 96, can say. Three acts: Arbitration Protocol and Convention, and Arbitration Act 1940, and Foreign Awards Recognition and Enforcement Act 1961 are hereby repealed. Notwithstanding such repeal, provisions of said enactments shall apply in relation to arbitral proceedings which commence before this Act came into force unless otherwise agreed by parties, but this Act shall apply in relation to arbitral proceedings which commence on or after this Act comes into force. All rules made and notifications published under said enactment shall, to extent to which they are not repugnant to this Act, be deemed respectively to have been made or issued under this Act. Comments: I'm not going to do enforcement of foreign awards. Now, repeal of Ordinance 27 of 1996, Ordinance repealed because there must be some ordinance. Now we'll go to what is that? This is first schedule, section 44, Convention of Recognition and Enforcement of Foreign Awards. Article 1, so it is first schedule, what it says. Let us see what it says. Article 1, this is Article 1, Article 2, how many articles are there? Let's see. Article 2, Article 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Then second schedule is also there, Protocol of Arbitration Clauses, and this is for section 53. And then there is third schedule, that is Convention of Execution of Foreign Awards. Articles are there. So likewise, so we will बहुत important होते हैं ऐसे provisions. We'll do one by one, we'll discuss, and before I'll try to give my views on. I like to refer to certain. Let's see what's Convention 1. This is Pehla schedule, Convention of Recognition and Enforcement of Foreign Arbitral Awards. This convention, let's brief it. This convention shall apply to recognition and enforcement of arbitral awards made in territory of a state other than state where recognition and enforcement of such awards are sought, and arising out of differences between persons, whether physical or legal. It shall also apply to arbitral awards not considered as domestic awards in state where their recognition and enforcements are sought. Term arbitral awards shall include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies to which parties have submitted. When signing, ratifying, or acceding to this convention, or notifying extension under Article 10 hereof, whatever state may on basis of reciprocity declare that it shall apply convention to recognition and enforcement of awards made only in territory of another contracting state. It may also declare that it shall apply convention only to differences arising out of legal relationship, whether contractual or otherwise not, which are considered as commercial under national law of state making such declaration. Article 2, ये आपने समझा होगा ना, स्टेट के इशू हैं, बात करेंगे बाद में, अभी बोल देते हैं समझने के लिए. आर्टिकल 2 कहता है ईच कॉन्ट्रैक्टिंग स्टेट शैल रिकॉग्नाइज an agreement in writing under which parties undertake to submit to arbitration all or whatever differences which have arisen or may arise between them in respect of definition or defined legal relationship, whether contractual or not or otherwise, concerning a subject matter capable of settlement by arbitration. Term agreement in writing include an arbitral clause in a contract or an arbitration agreement signed by parties or contained in an exchange of letters or telegrams. Court of a contracting state, when seized of an action in a matter in respect of which parties have made an agreement within meaning of this article, shall at request of one of parties refer parties to arbitration unless it finds that said agreement is null and void, inoperative and incapable of being performed. Article 3. Each contracting state shall recognize arbitral awards as binding and enforce them in accordance with rules of procedure of territory where award is relied upon under conditions laid down in following articles. They shall not be imposed substantially more onerous condition or higher fees or charges on recognition or enforcement, or you can say, of domestic arbitral awards. Article 4. To obtain recognition and enforcement mentioned in preceding article, party applying for recognition and enforcement shall at time of application supply duly authenticated original award or a duly certified copy thereof. Original agreement referred to Article 2 or a duly certified copy thereof. If said award or agreement is not made in official language of country in which award is relied upon, party applying for recognition and enforcement of award shall produce a translation of these documents into such language. Translation shall be certified by an official or sworn translator or by a diplomatic or consular agent. Article 5. Recognition and enforcement of award may be refused at request of party against whom it is invoked, only if that party furnishes to competent authority where recognition and information is sought proof that parties to agreement referred to in Article 2 were under law applicable to them under some incapacity, or said agreement is not valid under law to which parties have subjected it, or failing whatever indication thereon under law of country where award was made. Party against whom award is invoked was not given proper notice of appointment of arbitrator or of arbitration proceedings, or was otherwise unable to present case, or award deals with a difference not contemplated by or not falling within terms of submission to arbitration, or it contains decisions on matters beyond scope of submission to arbitration, provided that if decisions on matters submitted to arbitration can be separated from those not so submitted, that part of award which contains decisions on matters submitted to arbitration may be recognized and enforced, or composition of arbitral authority or arbitral procedure was not in accordance with agreement of parties, or failing such agreement was not in accordance with law of country where arbitration affected. Award has not yet become binding on parties, or has been set aside by or suspended by a competent authority of country in which or under law of which that award was made. Recognition and enforcement of an arbitral award may also be refused if competent authority in country where recognition and enforcement is sought finds that subject matter of difference is not capable of settlement by arbitration under law of that country. Recognition or enforcement of award would be contrary to public policy of that country. Article 6. If an application for setting aside or suspension of award has been made to a competent authority referred to in Article 5(1)(e), authority before which award is sought to be relied upon may, if it considers it proper, adjourn decision on enforcement of award, and also on application of party claiming enforcement of award order other party to be a suitable security. Article 7. Provisions of these to the present convention shall not affect validity of multilateral or bilateral agreements concerning recognition and enforcement of arbitral awards entered into by contracting states, nor deprive any interested party of whatever right one may have to avail itself of an arbitral award in manner and to extent allowed by law or treaties of country where such award is sought to be relied upon. Geneva Protocol on Arbitration Clauses of 1923 and Geneva Convention on Execution of Foreign Awards, Arbitral Awards 1997 shall cease to have effect between contracting states on their becoming bound and to extent that they become bound by this convention. Article 8. This convention shall be open until 31st December 1958 for signature on behalf of member of United Nations and also on behalf of other states which is thereafter. Becomes member of specialized agency of United Nations, and which is or hereafter becomes a party to statute of International Court of Justice or whatever other state to which invitation has been addressed by General Assembly of United Nations. This convention shall be ratified and instrument of ratification shall be deposited with Secretary General of United Nations. In Article 9, this convention shall be open for accession to all states referred to in Article 8. Accession shall be effected by deposit of an instrument of accession with Secretary General of United Nations. Article 10. Whatever state may at time of signature, ratification or accession, declare that this convention shall extend to all or whatever of territories for international relations of which it is responsible. Such a declaration shall take effect when convention enters into force for state concerned. At whatever time thereafter, and whatever such extension shall be made by notification addressed to Secretary General of United Nations and take effect as from 90th day after day of receipt by Secretary General of United Nations of this notification or as from date of entry into force of convention for state concerned, whichever is later. With respect to those territories to which this convention is not extended at time of signature, ratification or accession, each state concerned shall consider possibility of taking necessary steps in order to extend its application of this convention to such territories, subject where necessary constitutional reasons to consent of governments of such territories. Article 11. In case of federal or non-unitary state, following provisions shall apply with respect to these articles of this convention that come within legislative jurisdiction of federal authority. Obligations of federal government shall to this extent be same as those of contracting states which are not federal states. With respect to those articles of this convention that come within legislative jurisdiction of constituent state or provinces which are not under constitutional system of federation bound to take legislative action, federal government shall bring such articles with a favorable recommendation to notice of appropriate authorities of constituent states or provinces at the earliest possible moment. A federal state party to this convention shall, at request of any other or whatever else contracting state, transmit it through Secretary General of the United Nations, supply statement of law and practice of federation and its constituent units in regard to whatever particular provisions of this convention, showing extent to which effect has been given to that provisions by legislative or other action. This convention shall come into force on 19th day following date of deposit of this instrument of ratification or accession. For each state ratifying or acceding to this convention, after deposit of third instrument of ratification or accession, this convention shall enter into force on 19th day after deposit by such state of instrument of ratification or accession. Article 13. Whatever contracting state may denounce this convention by written notification to Secretary General of United Nations, denunciation shall effect 1 year after date of receipt of notification by Secretary General. Whatever contracting state may denounce this convention by a written notification to Secretary General of UN, denunciation shall effect 1 year after date of receipt of notification by Secretary General UN. State which has made a declaration or notification under Article 10 may at whatever time thereafter by notification of Secretary General of UN declare that this convention shall cease to extend to territory concerned in 1 year after date of receipt of notification by Secretary General. This convention shall continue to be applicable to arbitral awards in respect of which recognition or enforcement proceedings have been instituted before denunciation is effected. Article 14. A contracting state shall not be entitled to avail itself of present convention against other contracting states except to extent that it's itself bound to apply convention. Article 15. Secretary General of United Nations shall notify states contemplated in Article 8 of following: signatures and ratifications in accordance with Article 8, accession in accordance with Article 9, declaration and notification under Article 1, 10 and 11, date upon which this convention enters into force in accordance with Article 12, denunciations and notifications in accordance with Article 13, Article 16. Article 16. This convention, of which Chinese, English, French, Russian and Spanish texts shall be equally authentic, deposited in archives of United Nations. This convention which Chinese, English, French, Russian and Spanish texts shall be equally authentic, shall be deposited in archives of United Nations. Secretary General of United Nations shall transmit a certified copy of this convention to states contemplated in Article 8. Arbitration and Conciliation Act, second schedule. So first schedule and second schedule, that is section 53, Protocol of Arbitration Clauses. Protocol on arbitration clauses. Undersigned, being duly authorized, declare that they accept on behalf of countries which they represent following provisions. Each contracting state recognizes validity of an agreement, whether relating to existing or future differences between parties, subject respectively to jurisdiction of different contracting states, by which parties to a contract agree to submit to arbitration all or whatever differences that may arise in connection with such contract relating to commercial matters or to whatever other matter capable of settlement by arbitration, whether or not arbitration is to take place in a country to whose jurisdiction none of parties is subject. Each contracting state reserves right to limit obligation mentioned above to contracts which are considered as commercial under its national law. Contracting state which avails itself of this right shall notify Secretary General of League of Nations in order that other contracting states may be so informed. Arbitral procedure, including constitution of arbitral tribunal, shall be governed by will of parties and by law of country in whose territory arbitration takes place. Contracting states agree to facilitate all steps. Contracting states agree to facilitate all steps in procedure which require to be taken in their own territories in accordance with provisions of their law governing arbitral procedure applicable to existing differences. Each contracting state undertakes to ensure execution by its authorities and in accordance with provisions of its national laws of arbitral awards made in its own territory under preceding articles. Tribunals of contracting parties on being seized of a dispute regarding a contract made between persons to whom Article 1 applies, including an arbitration agreement, whether referring to present or future differences, which is valid in virtue of said article and capable of being carried into effect, shall refer parties on application of either of them to decisions of arbitrators. Such reference shall not prejudice competence of judicial tribunals in case of agreement or arbitration cannot proceed or becomes inoperative. Present protocol, which shall remain open for signature by all states, be ratified. Ratification shall be deposited as soon as possible with Secretary General of League of Nations, who shall notify such deposit to all signatory states. Present protocol shall come into force as soon as 2 ratifications have been deposited. Thereafter it will take effect in the case of each contracting state 1 month after notification by Secretary General of deposit of its ratification. Present protocol may be denounced by contracting state on giving 1 year's notice. Denunciation shall be effected by notification addressed to Secretary General of League, who shall immediately transmit copies of such notification to all other signatory states and inform them of date on which it was received. Denunciation shall affect 1 year after date on which it was notified to Secretary General and shall operate only in respect of notifying state. Contracting states may declare their acceptance of present protocol does not include any or all of under mentioned territories, that is to say, their colonies, overseas possessions or territories, protection of territories over which they exercise a mandate. Said states may subsequently adhere separately on behalf of any territory thus excluded. Secretary General of League of Nations shall be informed as soon as possible of such adhesions, shall notify such adhesions to all signatories state. They shall take effect 1 month after notification by Secretary General to all signatory states. Contracting states may also denounce protocol separately on behalf of territories referred to above. Arbitration Council Act, Third Schedule, Convention of Execution of Foreign Arbitral Awards. Article 1. In territories of high contracting parties to which present convention applies, arbitral award made in pursuance of an agreement, whether relating to existing or future differences, herein after called the submission to arbitration, covered by protocol on arbitration clauses, opened at Geneva on September 24, 1923, shall be recognized as binding and shall be enforced in accordance with rules of procedure of territory where award is relied upon, provided that said award has been made in territory of one of high contracting parties to which present convention applies, and between persons who are subject to jurisdiction of one of high contracting parties. To obtain such recognition or enforcement, it shall further be necessary that award has been made in pursuance of submission to arbitration which is valid under law applicable thereto, that subject matter of award is capable of settlement by arbitration under law of country in which award is sought to be relied upon, that award has been made by arbitral tribunal provided for in submission to arbitration or constituted in manner agreed upon by parties and in conformity with law governing arbitration procedures, that award has become final in country in which it has been made, in sense that it will not be considered as such if it is open to opposition, appeal or poverty and cessation in countries where such forms of procedure exist, or if it is proved that whatever proceedings for purpose of contesting validity of awards are pending, the recognition or enforcement of award is not contrary to public policy or to principles of law of that country in which it sought to be relied upon. Article 2. Even if conditions laid down in Article 1 hereof are fulfilled, recognition and enforcement of award shall be refused if court is satisfied that the award has been annulled in country in which it was made, that a party against whom it sought to use award was not given notice of arbitration proceedings in sufficient time to enable to present its case, or that being under a legal capacity was not properly represented. That the award does not deal with differences contemplated by falling within terms of submission to arbitration, or that it contains decisions on matters beyond scope of submission to arbitration. If award has not covered all questions submitted to arbitral tribunal, competent authority of a country where recognition or enforcement of award is sought can, if it thinks fit, postpone such recognition or enforcement, or grant is subject to such guarantee as that authority may decide. Article 3. If party against whom award has been made proves that under law governing arbitration procedures is a ground other than grounds referred to in Article A to C, and Article 2 B to C and C, entitling him to contest validity of award in the court of law, court may, if it thinks fit, either refuse recognition or enforcement of award or adjourn consideration thereof, giving such party a reasonable time within which to have award annulled by competent tribunal. Article 4. Party relying upon an award or claiming its enforcement must supply in particular. Original award, the copy thereof be duly authenticated. Original award, the copy thereof of duly authenticated according to requirements of law of country in which it was made. Documentary or other evidence to prove that award has become final in a sense defined in article and the country of which in which it was made. When necessary, documentary or other evidence to prove that conditions laid down on Article 1, Paragraph 1 and Paragraph 2 and A and C have been fulfilled. A translation of award and of other documents mentioned in this article into official language of country where award is sought to be relied upon may be demanded. Such translation must be certified correct by a diplomatic or consular agent of country to which party Article 5 let me say again, a translation of award and of other documents mentioned in this article into the official language of country where the award is sought to be relied upon may be demanded. Such translation must be certified correct by a diplomatic or consular agent of country to which party who seeks to rely upon award belong by sworn translator of country where award is sought to be relied upon. Article 5. Provisions of above articles shall not deprive the interested party of right of availing itself of an arbitral award in manner and to extent allowed by law treaties of country where such award is sought to be relied upon. Article 5. Provisions of above articles shall not deprive any interested party of right of availing itself of an arbitral award in manner and to extent allowed by law or treaty of country where such award is sought to define. Provisions of articles shall not deprive any interested party of right of availing itself of arbitral award in manner and to extent about allowed by law of the treaty of countries where such award is sought to be relied upon. Present convention applies only to arbitral award made after coming into force of protocol of arbitration, clause open in Geneva, September 24th. And present convention, which remain open to signature of all signatories of protocol of 1923 on arbitration clauses, shall be ratified. It may be ratified only on behalf of those members of League of Nations and non-member states on whose behalf Protocol of 1923 shall have been ratified. Ratification shall be deposited as soon as possible with Secretary General of League of Nations, who shall notify such deposit to all signatories. Article 8. This convention shall come into force 3 months after it shall have been ratified on behalf of 2 high contracting parties. Thereafter, it shall take effect in case of each high contracting party 3 months after deposit of ratification on its behalf the Secretary General of League of Nations. Present convention may be denounced on behalf of member of League of non-member state. Denunciation shall be notified in writing to Secretary General of League of Nations, who immediately send a copy thereof certified to be in conformity with notifications to all other contracting parties at same time, informing them of date on which received it. Denunciation shall come into force only in respect of high contracting party, which shall have notified it, and 1 year after such notification shall have reached Secretary General of League of Nations. Denunciation of protocol in arbitration clauses shall entail ipso facto denunciation of present convention. Present convention does not apply to colonies, protectorates, or territories under suzerainty or mandate of high contract parties unless they are specially mentioned. Application of this convention or one or more such colonies, protectorates or territories to which protocol or arbitration clauses opened at Geneva on September 24, 1923 applies, can be effected at whatever time by means of declaration addressed to Secretary General of League of Nations by one of high contracting parties. Such declaration shall effect 3 months after deposit thereof. High contracted parties can at whatever time denounce convention for all or whatever of colonies, protectorates or territories referred to above. Article 9 hereof apply to such denunciations. A certified copy of present convention shall be transmitted by Secretary General of League of Nations to every member of League of Nations and to every non-member state which signs them. Recently, on September 6, 2012, 5 members Constitutional Bench of Indian Supreme Court in Bharat Aluminium Company versus Kesar Aluminium Technical Service Balco judgment, after reconsidering its various previous decisions on Indian Arbitration and Contract Act 1996, concluded that Indian Arbitration Act should be interpreted in a manner to give effect to intent of Indian Parliament. In Balco judgment, the Supreme Court reversed its earlier ruling in case of Bharti International was a bulk trading Adventure Global Engineering or Satyam Computer Services, stating that findings in these judgments were incorrect. Based on Balco judgment, following is a new legal position with respect to arbitrations law in India, which is in line with intention of Parliament when they enacted Indian Arbitration Act 1996. Indian Arbitration Act has accepted territoriality principle, which has been adopted in UN Citral law. Accordingly, Part 1 of Indian Independent Arbitration Act, Part 1 of Indian Arbitration Act applies only to arbitrations taking place in India, irrespective of whether such arbitrations take place between Indian parties or between Indian and foreign parties. Domestic awards. Domestic awards can be challenged and are enforceable under Part 1 of Indian Arbitration Act. Part 1 of Indian Arbitration Act has no application to arbitration seated outside India, irrespective of whether parties choose to apply to Indian Arbitration Act or not. Grounds to challenge of award given in Part 1 of Indian Arbitration Act are thus applicable only to domestic awards and not to foreign awards. Law of seat of a place where arbitration is held is normally law to govern arbitration. If agreement provides for a seat of place outside India, Part 1 of Indian Arbitration Act would be inapplicable to extent inconsistent with arbitration law of seat place. even if agreement purports to provide that Indian Arbitration Act shall govern the arbitration proceedings. In case of domestic awards, Indian laws shall prevail if substantial law conflicts with laws of India. In case of foreign awards, conflict of laws, rules of country in which arbitration takes place would have to be applied. There is no provision under Civil Procedure Code 1908 or under Indian Arbitration Act for a court to grant interim measures in terms of Part 1 of Indian Arbitration Act. In arbitrations which take place outside India, even though parties by agreement may have made Indian Arbitration Act as governing law of arbitration, an inter-party suit simply for interim relief pending arbitration outside India would not be maintainable in India. The regulation of conduct of arbitration and challenge would be done by courts of country in which arbitration is conducted. Accordingly, a foreign award can be annulled by court of country in which award was made. Country of procedural curial law and not before court of country under law of which award was made. Country of substantial law, it can be challenged in court of second alternative only if court of first alternative had no power to annul award under its national laws. Indian Arbitration Act intentionally limits it to awards made in pursuance of an agreement to which New York Convention or Geneva Protocol applies. Therefore, no remedy is provided for enforcement of non-conventional awards under Indian Arbitration Act. Most importantly, these findings of Supreme Court are applicable only to arbitration agreements executed after 6 September 2012. Thus, all disputes pursuant to arbitration agreement entered into up to 6 September 2012 shall be decided by old precedents irrespective of fact that, according to Supreme Court, such rulings were incorrect and have been reversed. It's noted that foreign investors, parties have been facing problems in enforcing foreign awards in India against Indian parties because earlier Supreme Court consistently held that provisions of Part 1 of the Indian Arbitration Act are applicable to foreign awards as well. Thus, foreign awards were subject to interference by Indian courts both during pendency of arbitration proceedings and at enforcement stage because Indian parties were entitled to challenge foreign awards on various grounds available under Part 1 of Indian Arbitration Act. Also, under such proceedings, foreign awards were challenged on merits as well as before Indian courts. Therefore, now in view of Balgo judgment, Indian parties will no more enjoy such protections if place seat of administration is outside India. New Arbitration and Conciliation Law of India Introduction. In past, statutory provisions on arbitration were contained in 3 different enactments, namely Arbitration Act 1940, Arbitration Protocol and Convention Act 1937, and Foreign Awards Recognition and Enforcement Act 1961. Arbitration Act laid down framework within which domestic arbitration was conducted in India, while other 2 acts dealt with foreign awards. Arbitration and Conciliation Act 1996 has repealed Arbitration Act 1940 and also Acts of 1937 and 1961. Consolidated and amended law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards. It also defines law relating to conciliation, providing for matters connected therewith, and incidental thereto on basis of model law on international commercial arbitration, adopted by UN Commission on International Trade Law, UN Citral in 1985. Ordinance which was promulgated by President of India on 16th January 96 was brought into force with effect from 25th January 1996. Arbitration and Conciliation Bill 1996 was passed by both Houses of Parliament and received President assents on 16th August 1996 and came on statute books as Arbitration and Conciliation Act 1996. Some notable features of Act may be briefly mentioned at this stage. Most important departure made by Act from previous law is in regard to judicial intervention with process and product of arbitration. Firstly, where there is an arbitration agreement, judicial authority is required to direct parties to resort to arbitration per agreement, provided application for that purpose is made before or when a written statement on merits is submitted to judicial authorities by parties seeking arbitration. Secondly, grounds on which award of an arbitration may be challenged before courts have been severely cut down, so that broadly speaking, such a challenge shall now be permitted only on basis of invalidity of agreement, want of jurisdiction on part of arbitrator, or want of proper notice to a party of appointment of arbitrator or of arbitral proceedings, or a party being unable to present the case. Same time, an award can now be set aside if it is in conflict with public policy of India, a ground which covers inter alia fraud and corruption. Thirdly, powers of arbitrator itself have been amplified by inserting specific provisions on several matters, such as law to be applied by it, power to determine venue of arbitration, failing agreement, power to appoint experts, power to act on report of a party, power to apply to court for assistance in taking evidence, power to award interest, and so on. Fourthly, obstructive tactics, sometimes adopted by parties in arbitration proceeding are sought to be thwarted by express provisions whereunder a party who knowingly keeps silent and then suddenly raises a procedural objection shall not be allowed to do so. Fifthly, role of institution in promoting an organization arbitration has been recognized. Sixthly, power to nominate arbitrators has been given, failing agreement between parties to Chief Justice or to an institution or person designated by it. Seventhly, time limit for making award has been deleted. Eighthly, present provisions relating to arbitration through intervention of court when there is no suit pending, or by order of court where there is a suit pending, have been removed. Ninthly, importance of translational, a commercial arbitration has been recognized, and it has been specifically provided that even where arbitration is held in India, Parties to contract would be free to to designate law applicable to substance of dispute. Finally, unless our agreement provides otherwise, arbitrators are required to give reasons for award. Award itself has now been vested with the status of a decree. Inasmuch as subject to the power of court to set aside award itself is made executable as a decree, and it shall no longer be necessary to apply to court for a decree in terms of award. In following paragraph, attempt has been made to present an analytical study of Arbitration Act 1940 and New Arbitration Act and Constitutional Law. Settlement of disputes by arbitration has been practiced in India from distant past, and legal literature tells us of ancient times of arbitration for resolving disputes concerning family or trade or a social group. Constitution of India also puts it as a directive principles of state policy that state should encourage settlement of international disputes by arbitration. Some basic expression relating to arbitration. Some expressions which are commonly used in arbitrations, though statutorily defined, may be briefly explained. Domestic arbitration. Term domestic arbitration denotes arbitration which affects in India when subject matter of contract, merits of dispute and procedure for arbitration are all governed by Indian law, or when cause of action for dispute has arisen wholly in India, or where parties are otherwise subject to Indian jurisdiction. New law makes a mention of domestic arbitration in long title and preamble, and of domestic award in section read with section other one. International arbitration. International arbitration has a foreign ingredient. Arbitration becomes international when at least one of parties involved is resident or domiciled outside India, or subject matter of dispute is abroad. Law applicable to an arbitration proceedings may be Indian law or a foreign law, depending on terms of contract in this regard and rules of conflict of laws. Section 21 of new law defines international commercial arbitration as arbitration relating to disputes arising out of legal relationship, whether contractual or not. Consider this commercial under law in force in India, where either one of parties is an individual who is a national law or habitually resident in any other country other than this country, India, or a body corporate which is incorporated in other country other than India. A company or an association, a body of individuals whose central management or organization and control is exercised in whatever country other than India. Government of a foreign country. Foreign arbitration. Foreign arbitration is an arbitration conducted in a place outside India, where resulting award is sought to be enforced as a foreign award. Ad hoc arbitration. Ad hoc arbitration is arbitration agreed to and arranged by parties themselves without recourse to an institution. Proceedings are conducted by arbitrators per agreement between parties or with concurrence of parties. It can be domestic, international, or foreign arbitration. Institutional arbitration. Institutional arbitration conducted under rules laid down by an established arbitral organization. Such rules are meant to supplement provisions of Arbitration and Conciliation Act in matters of procedures and other matters same permits. Rules may provide for domestic arbitration or for international arbitration or for both, and disputes delay considerably. Rules may provide for domestic arbitration or for international arbitration for both, and the disputes dealt with may be either general in character or specific. Of many organizations providing facilities for arbitration, only a few cater to settlement of international disputes. Among them, most important in India are Indian Council of Arbitrators, Indian Council of Arbitration, Federation of Indian Chambers of Commerce and Industry, Bengal Chambers of Commerce and Industry, Indian Chamber of Commerce in East India, Cotton Association Limited and Cotton Textiles Export Promotion Council, Bengal Chamber of Commerce, though providing facilities for arbitration for all commercial disputes, administers arbitration primarily in jute trade. East India Cotton Association and Cotton Textile Export Promotion Council likewise deal with settlement of disputes in the field of foreign cotton trade and foreign trade in textile respectively. The facilities of international arbitration are available with all these organizations. Indian Council of Arbitration, being apex body, has handled maximum number of international arbitration cases in India. While there was no specific reference to international arbitration in old Act, though such arbitration has been long established and availed of, new Act expressly recognizes role of arbitral institutions in order to facilitate conduct of new arbitral learning. Administrative assistance of a suitable institution further expressly facilitate, you can say, adoption of institutional with consent as Section 6 provides. There was no specific reference to institutional arbitration in old Act. Such arbitration has been long established and availed of. New Act expressly recognizes the role of arbitral institutions in order to facilitate conduct of arbitral proceedings. Section 6 provides that parties or arbitral tribunal with consent of parties may arrange for administrative assistance of a suitable institution. Specialized arbitration. Specialized arbitration is arbitration conducted under auspices of arbitral institutions which might have framed special rules to meet specific requirements for conduct of arbitration in respect of disputes of particular types, such as disputes as to commodities, construction, or specific areas of technology. Some trade associations concerned with specific commodity administer assistance of a suitable institution. Now, specialized arbitration, I said the specialized arbitration conducted under auspices of arbitral institutions which might have framed special rules to meet the specific requirements for the conduct of arbitration in respect of disputes of particular types, such as disputes as to commodities, construction, or specific areas of technology. Some trade associations concerned with specific commodities or Chamber of Commerce also specify that arbitration under the rule shall be conducted only between members of that organization. Statutory arbitration. Statutory arbitration. Statutory arbitrations are arbitrations conducted in accordance with provisions of certain special acts which provide for arbitration in respect of disputes arising on matters covered by those acts. There are about 24 such central acts. Among them are Cantonment Act 1924, Indian Electricity Act 1910, Land Acquisition Act 1894, Railways Act 1890, and the Forward Contracts Regulation Act 1936. Statutory arbitrations conducted in accordance with provisions of certain special acts which provide for arbitration in respect of disputes arising on matters covered with these acts. About you can say Electricity Act 10, Land Acquisition Act, Railway Acts, and Forward Contract Regulation Act 1936. Many states acts also provide for arbitration in respect of disputes covered by those acts, including acts relating to cooperative societies. Provisions of Arbitration Act 1940 generally apply to those arbitrations unless they are inconsistent with particular provisions of those acts, in which case provisions of those acts will apply. New law. Above position continues to sustain in substance under the new act. Submission to arbitration is a reference. Submission to arbitration is a reference by parties of a dispute between them to arbitration. It's not a term defined as such in new law, though the word submit is used. Arbitration clause. In the arbitration clause is a clause contained in and forming part of main contract for reference to arbitration of differences between parties. Differences may be present, already arisen, or future likely to arise in future. In legal phraseology, it can constitute an arbitration agreement. New law. New law maintains our position in substance, but deals in some detail with subject. Practice of arbitration in India, all different forms of arbitration, ad hoc, institutional, specialized, and statutory, have been practiced in India. New law expressly recognizes institutional arbitration and also permits ad hoc arbitration, specified arbitration, and statutory arbitration. However, remain unaffected by new law. Says new law expressly recognizes institutional arbitration and also permits ad hoc arbitration, specified arbitrations, and statutory arbitrations, however, remain unaffected by new law. Alright. International multinational conventions. India is party to Geneva Protocol in arbitration clauses of 1923, Geneva Convention on execution of foreign arbitral awards, 1927, and New York Convention of 1958 on recognition and enforcement of foreign arbitral awards. It became a party to 1958 Convention on 10th June 1958 and ratified it on 30th July 1961. India has enacted implementing legislations to give effect to protocol and two conventions. Arbitration Protocol and Convention Act 1937, which came into force on 4th March 37, gave effect to Protocol of 1923 and Convention of 1927. It provides for enforcement of arbitral agreements to which protocol applies and enforcement of foreign tribal arbitral awards to which convention in 1927 applies. Foreign Award Recognition and Enforcement Act 1961 which came into force on 30th November. So you can say foreign awards, protocol, it provides for enforcement of arbitral agreements to which protocol applied and enforcement of foreign arbitral awards to which Convention of 1920 applied. Foreign Awards Recognition and Enforcement Act 1961, which came into force on 30th November 1961, had been enacted pursuant to New York Convention of 1958, and it presented law and procedures for enforcement of foreign award in India, to which said convention applied. Act of 1937, 1961 mentioned above have been repealed in New Act, Part 2 of which incorporates their operative provisions. Bilateral conventions. There are no bilateral conventions between India and any other country concerning arbitrations. Judicial decisions. Matters arising out under 3 repealed acts, namely Arbitration Act 1940, Arbitration Protocol and Convention Act 1937, and Foreign Awards Recognition and Enforcement Act 1961. Matter arising under 3 repealed acts, namely Arbitration Act 1940, Arbitration Protocol and Convention, and Foreign Awards Recognition and Enforcement 1961, have been subject matter of decisions by Privy Council before 1949. High Courts and Supreme Courts of India. Law expounded by courts is as much part of law as statute. The law expounded by court is as much part of law as statute. A few important decisions have also been handed down by Supreme Court and High Court interpreting provisions of 1937 and 1961 Acts. These decisions, to the extent that these are not inconsistent with the new Act, shall continue to have their binding force. These are certain amendments which you have made in amendment by amendment, let you know about qualifications. And this is particularly very important from various viewpoints, and I think we can, for example, yes, already. You have to give me some time. We're already 3 hours over, and here important is which qualifications are given here. Here is about qualifications and experience of arbitrator. A person shall not be qualified to be an arbitrator unless it's about advocate, about chartered accountant, about cost accountant, about company secretary, or in a legal service office, like that, officer in law degree, an officer with engineering degree, an officer having senior level, and in any other case. We have to understand these provisions for our own. We should not keep ourselves off from this. That's an important point. A few minutes in between. And if this video continues, I'll continue because I have to talk to you about certain changes, certain amendments in 2000. That is I think there are 3 amendments, and we have to understand them. What are those? And that is very important point. This is one, there will be 2 more. We will go one by one. Many I already discussed with you. मैंने पहले भी आपसे कुछ बातें की थी इसके बारे में. इसको हम डिस्कस करेंगे और देखेंगे इसको कैसे आगे किया जाए, कैसे बढ़ाया जाए. It's very important point, and it works very well, and we cannot say no to this. Let us see if video continues. We'll see. Give me 5 minutes, please. I'll be back. Let us see what happens, whether it is still working or not working. Let me make sure it is still working, I think. And let us see how it works. Just make up on this. In this 9, or this is 2019, so this is 2019 Ministry of Law and Justice. In 2019, 2018 is same. So short title is same, otherwise no problem. Arbitral institution is defined. That is, you can say arbitral institution means arbitral institution designated by Supreme Court or High Court under this Act. Then regulations, etc. So Supreme Court and the High Court shall have powers to designate arbitral institutions. That's another one. And of course, courts were defined, something else was defined. This is that one. Then you can say anything specific. I'm just trying to find. Says fees, etc. Arbitral tribunal shall determine fees of arbitral tribunal and manner of its payments to arbitral tribunal. Subsidies, okay, specified in 4th schedule. This is another one, and you can say that says where matter referred to in this 4, 5, 6, arising in international commercial arbitration or other arbitration reference to arbitration institute in those shall be considered as reference to the arbitral institution designated on this. Application made on this section for appointment of an arbitrator shall be disposed of by arbitral institutions within a period of 30 days from date of service of notice. Arbitral institutions shall determine fees of arbitral tribunals, manner payment. Okay, then for removal of doubts, it is clarified that this subsection shall not apply to international commercial arbitration and in arbitrations where parties have agreed for the determination of fees per rules of arbitral institutions. Statement of claims and defense under this section shall be completed within a period of 6 months. A statement of claims and defense shall under this section be completed within a period of 6 months. That's section 23. From date of arbitration, or arbitrators, as case may be, receive notice or writing. So statement of claims and defense under this section shall be completed within a period of 6 months from date of the arbitrator or arbitrators, as case may be, receive notice in writing of their appointment. Then award in matters other than international commercial arbitration shall be made by arbitral tribunal within a period of 12 months from date of completion of pleadings. Provide that award in matter of international commercial arbitration may be made as expeditiously as possible, and endeavor may be made to dispose of matter within a period of 12 months from date of completion of pleadings. But for that, where the publication under section is pending, mandate of arbiter shall continue till disposal of said application. Provided also that arbiter shall be given an opportunity of being heard before fee is reduced. In section 34 of Principal Act is if for word furnishes proof that word establishes on the basis of record of arbitral tribunals, that shall be established. Section 37, appeal of word notwithstanding anything contained either of law for time being enforced, an appeal shall be substituted. Okay. Notwithstanding anything contained in either law for time being enforced, arbitral tribunal and parties to arbitration agreement shall maintain confidentiality of all arbitral proceedings except award, where its disclosure is necessary for purpose of implementation and enforcement of award. No suit or other legal proceedings shall lie against the arbitrator for anything which is in good faith done or intended to be done under this Act or rules or regulations made thereunder. Now, Arbitration Council of India, so this is defined. This part, unless context otherwise requires, chairperson means chairperson of Arbitration Council of India. Council means Arbitration Council of India, established under Section 33B. Member means member of council and includes chairperson. Central government shall by notification of official gazette establish purpose of this act. A council to be known as Arbitration Council of India to perform duties and discharge of functions under this act. Council shall be a body corporate by name aforesaid, having perpetual succession and common seal with power subject to provisions of this act. To acquire, hold and dispose of property, both movable and immovable, and enter into contract, and shall by said name head office of council shall be in Delhi. Council may, with prior approval of central government, establish offices at other places in India. Council shall consist of following members: a person who has been judge of the Supreme Court or Chief Justice of High Court or Judge of High Court, or an eminent person having special knowledge and experience in conduct or administration of arbitration, to be appointed by central government in consultation with Chief Justice of India, chairperson. An eminent arbitration practitioner having substantial knowledge and experience in institutional arbitration, both domestic and international, to be nominated by central government. An eminent academician having experience in research and teaching in field of arbitration and the alternative dispute resolution laws, to be appointed by central government in consultation with chairperson. Secretary to Government of India in the Department of Legal Affairs, Ministry of Law and Justice, or its representative not below rank of Joint Secretary. Secretary to Government of India in Department of Expenditure, Ministry of Finance, or its representative not below rank of Joint Secretary. One representative of recognized body of commerce and industry, chosen on rotational basis by central government. Chief Executive Officer, Member Secretary. Chairperson, members of council other than ex officio members such shall hold office as such for a term 3 years from date on which they upon enter the office, provided that no chairperson member other than ex officio members shall hold office as such after it has attained the age of 70 years in the case of chairperson and 67 years in case of member. Salaries, allowance and other terms and conditions of chairperson members referred shall be such as may be prescribed by central government. Part-time members shall be entitled to such travelling and other allowances as may be prescribed. It shall be the duty of council to take all such measures as may be necessary to promote and encourage arbitration, mediation, conciliation, or other alternative dispute resolution mechanism, and for that purpose to frame policy and guidelines for establishment, operation and maintenance of uniform professional standards in respect of all matters relating to arbitration, for purpose of performing duties and discharging functions under this act, from frame policies governing grading of arbitral institutions, recognize professional institutions, providing accreditations of arbitrators, review grading of arbitral institutions and arbitrators, hold training workshops and courses in area of arbitration and collaboration with law firms, law universities and arbitral institutes, frame, review and update norms to ensure satisfactory level of arbitration and conciliation, act as a forum for exchange of views and techniques, to be adopted for creation of a platform to make India a robust center for domestic and international arbitration and conciliation, make recommendations to central government on various measures to be adopted to make provisions for easy resolution of commercial disputes, promote institutional arbitration by strengthening arbitral institutions, conduct examination and training on various subjects relating to arbitration, conciliation and award certificate thereof, establish and maintain depository of arbitral awards made in India, make recommendations regarding personnel, training and infrastructure of arbitral institutions, such other functions as may be decided by central government. No act or proceeding of council shall be invalid merely by reasons of vacancy or defect in constitution of council, defect in appointment of person acting as member, irregularity in procedure of council not affecting merits. Chairperson full-time or part-time member may by notice in writing under its hand address to the government resign from office. Provided chairperson or full-time member shall, unless he is permitted by central government to relinquish office sooner, continue to hold office until expiry of 3 months from the date of receipt of such notice, or until a person duly appointed as a successor enters upon the office, or until expiry of terms of office which are earlier. Central government may remove a member from its office if it is undischarged or insolvent, has engaged at any time during its term of office in paid employment, has been convicted of offence which, in opinion of central government, involves moral turpitude, has acquired such financial or other interest as likely to affect prejudicially its functions, has abused position as render continuance in office, become physically, mentally incapable. Notwithstanding anything contained in subsection, no member shall be removed from office on grounds specified in the clause of that subsection, unless Supreme Court, on reference being made to it in its behalf by central government, has on an inquiry held that it might, in accordance with such procedure, is may prescribed, reported that member ought on such grounds to be removed. Council may appoint such experts, constitute such committees of experts as may consider necessary to discharge its functions on such terms and conditions as may be specified. Council shall make grading of arbitral institutions on basis of criteria relating to infrastructures, quality and caliber of arbitrators, performance and compliance of time limits for disposal of domestic or international commercial arbitrations in such manner as may be specified by regulations. Qualifications, experience and norms for accreditation of arbitration such as specified in English schedule, 8 schedule, provided central government may, after consultation with council, by notification in official gazette, amend 8th schedule, and thereupon 8th schedule shall be deemed to have been amended accordingly. Council shall maintain the electronic depository of arbitral awards made in India and such other records related thereto in such manner as may be specified by regulations. Council may, in consultation with central government, make regulations consistent with provisions of this Act and rules made thereunder for discharge of functions and performance duties under this Act. Chief Executive Officer of Council shall be responsible for day-to-day administration. Qualification, appointments, and terms and conditions of such officers shall be such as may be prescribed. Chief Executive Officer shall discharge his functions and performs duties per regulations. She shall be Secretary to Council, consisting of such number of officers and employees as prescribed. Qualifications, appointments, other council terms and conditions of service employees shall be per central government. And in section 50, an appeal, whether not contained any the law for time being forced, an appeal shall be substituted. After section 86 of the Municipal Act, following sections shall be inserted and shall be deemed, unless parties otherwise agree. Amendments made to this Act by Arbitration Council shall not apply to arbitral proceedings commenced before the Act. Court proceedings arising out of relations, such arbitral proceedings are also whether such court proceedings are commenced prior to or after commencement of the Act, apply only to arbitral proceedings commenced on or after commencement of Arbitration Act 2015, and to court proceedings arising out of relation after 7th schedule, principal is 8th schedule now. It is qualifications of members. Qualifications of members. No, there are certain definition qualifications here. Means it says, suppose you're an advocate. Its meaning of advocate act, you are means you are a registered advocate, and you have 10 years of practice experience as an advocate. That's what qualification is. And same thing applies to chartered accountants. You remember, should be a chartered accountant with 10 years experience, and also it applies to you can say also cost accountant, same condition, company secretary, same condition, 10 years experience, then officer of Indian legal service or has been an officer with law degree having 10 years experience in legal matters in government, autonomous bodies, public sector, undertaking, or at senior level managerial position in private sector, or with engineering degree. It's very important for me, for you, has been an officer with engineering degree having 10 years of experience as an engineer in government, in autonomous body, public sector undertaking, or at a senior level managerial position in private sector, or self-employed, or has been an officer having senior level experience of administration in central government or state government, or having experience of senior level management of a public sector undertaking, government or company or private company of repute. And it's a person in any other case having educational qualification at degree level with 10 years of experience in scientific or technical stream in fields of telecom, information technology, intellectual property rights, or other specialized areas in government, autonomous body, public sector undertaking, or a senior level managerial position in a private sector as case may be. General norms applicable to arbitrator. Arbitrator shall be a person of general reputation of fairness, integrity and capable. Arbitrator shall be a person of general reputation of fairness, integrity, and capable to apply objectivity in arriving at settlement of disputes. Arbitrator must be impartial and neutral and avoid entering into whatever financial business or other relationship that is likely to affect impartiality or might reasonably create an appearance of partiality or bias amongst parties. Arbitrator should not involve in any legal proceedings and avoid any potential conflict connected with whatever dispute to be arbitrated by it. Arbitrator should not have been convicted of an offense involving moral turpitude or economic offense. Arbitrator shall be conversant with Constitution of India, principles of natural justice, equity, common and its customary laws, commercial laws, labor laws, laws of torts, making and enforcing arbitral awards. Arbitrator should possess robust understanding of domestic and international legal system on arbitration and international best practices in regard thereto. Arbitrator should be able to understand key elements of contractual obligations in civil and commercial disputes, and able to apply legal principles to a situation under dispute, and also to apply judicial decisions on a given matter relating to arbitration. Arbitrator should be capable of suggesting recommendations or writing. Arbitrator should be capable of suggesting, recommending, or writing a reasoned and enforceable arbitral award in whatever dispute which comes before it for adjudication. Arbitration and Conciliation Act 2015 shall be omitted. Section 26 of Arbitration and Conciliation Act 2015 shall be omitted and shall be deemed to have been omitted with effect from 23rd. In fourth schedule, the Principal Act for brackets, words and figures, brackets, words, figures, letter shall be substituted. This is Arbitration Act 2015. I think it is 2000. It is 19. Like, let's go to 2015 also was for review. I'll close this and take another glimpse of that. 2015. Let us see what says that. If I can say what's that one. Let me see if I can find something here. Yes, this is I think 1215 one which I'm looking for. This is on this notification of 2016, and of course this says certain clauses are inserted. Scope is defined, redefined, but the scope is not clear. It's not much important for the arbitrator to say. Communication afterwards. Communication is towards particularly communication through electronics medium. Okay. Of course, give you high court. This, then it is. Only difference is that in foreign arbitration, Chief Justice of India is empowered, not High Court Justice, Chief Justice. If it is international contract, international commercial arbitration, so central government and or the approval etc. are same. If central government certify that it's necessary experience so do it mean notification of Gazette amendment fourth schedule, the copy of it. Okay, it's okay. It's not very important. The person is opposed connection with this possible appointment about it. We shall disclose. Yeah, that's important. In Section 12 of Principal Act. In Section 12 of Principal Act, for subsection, following subsection shall be substituted. Namely, when a person is approached in connection with this possible appointment as an arbitrator, shall disclose in writing whatever circumstances you can say. You have to disclose that. That's an important point here, such as existence. That is, existence either direct or indirect, a past or present relationship with or interest in parties or in party in relation to subject matter dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to its independence or impartiality, which are likely to affect its ability to devote sufficient time to arbitration and, in particular, ability to complete entire arbitration within a period of 12 months. That's 12 months the point. If you don't have time, you can't take more responsibility. 12 months. Of course, is a very long period for me if parties cooperate. Ground is stated in the fifth schedule which will guide in determining whether circumstances exist which give rise to justifiable doubts as to independence or impartiality of the arbitrator. Disclosure shall be made by such person in form specified in sixth schedule. After subsection, following section shall be inserted, and that is notwithstanding prior agreement. Notwithstanding prior agreement to contrary person whose relationship with parties of counsel or subject matter of dispute falls under category specified in seventh schedule shall be ineligible to be appointed as an arbitrator, provided that parties may subsequent to dispute having arisen between them waive applicability of this subsection by an express agreement in writing. In section 14 of Principal Act, in opening portions of a mandate of an arbitrator shall terminate if mandate of an arbitrator shall terminate and shall be substituted by another arbitrator. Section 17 shall be substituted, namely as party may during arbitral proceedings or at whatever time after making of an arbitral award, but before it is enforced in accordance with section 6 apply to arbitral tribunal. For appointment of guardian for a minor or person of unsound mind for purpose of arbitral proceedings, for an entry measure of protection in respect of any of following matters: preservation, interim custody or sale of any good, just subject matter of arbitration agreement, securing amount of dispute or arbitration, detention, preservation or inspection of property or thing which is subject matter of dispute and arbitration or as to which question may arise therein, authorizing for whatever any of posted purposes person to enter upon land or building in possession of party, authorizing samples to be taken, observation to be made or experiment to be tried which may be necessary or expedient for purpose of obtaining full information evidence, interim injection or appointment of receiver, such other interim measures or protection as may appear to arbitral tribunal to be just and convenient, and arbitral tribunal shall have same power for making orders as court has for purpose of and relation to any proceedings before it. A party may during arbitral proceedings or at any time after making of arbitral award but before it's enforced in accordance with sections of the arbitral tribunal. So this is appointment of guardian, protection and deposit and detention, etc., etc., interim injunction, all this is given here. Subject to any orders passed and appeal under section 37, an order issued by arbitral tribunal under this section shall be deemed to be an order of court for all purposes and shall be enforceable at the Code of Civil Procedure 1908 in same manner as if an order of court. In section of the Municipal Code, following section less 23, it says the following subsection shall be inserted. Respondent in respect of his case may also submit a counterclaim or plead a set-off which shall be adjudicated upon arbitral tribunal if such counterclaim or set-off falls within scope of arbitration agreement. In section 24 of Principal Act, after provisions of section following provisions shall be inserted, provided for that arbitral tribunal shall as far as possible hold oral hearings for presentation of evidence or for oral argument on day-to-day basis and not grant any adjournments unless sufficient cause is made out, and may impose costs including exemplary costs on parties seeking adjournment without any sufficient cause. Very important one. Section 24 of Principal Act, after provisions of section 1I following shall be inserted, provided further that arbitral tribunal shall as far as possible hold oral hearings for presentation of evidence or for oral argument on day-to-day basis and not grant adjournments unless sufficient cause is made out, and may impose costs including exemplary costs or on parties seeking adjournment without any sufficient cause. In section 25 Principal Act, at end afterwards allegations by claimant words and shall have discretion to treat right of respondent to file such a statement of defense as having been forfeited shall be inserted. Such and afterwards allegations by claimant SB words and shall have in discretion to treat right of respondent to file such a statement of defense as having been forfeited. This is 25. It's 25. If we go to 25, we can know what is that first of all. To 24 and 25. Defaults of party and it says default of parties, this is B. If respondent fails to communicate its statement of defense in accordance with subsection 1 of section 23, arbitral tribunal shall claim to claim proceedings without treating that failure in itself as an admission of allegations by claimant. And what it says in this? It says in this, while in section 25b, it says in section 25b, respondent fails to communicate statement of defense in accordance with subsection 1 of section 23, arbitral tribunal shall continue proceedings without treating that failure in itself as an admission of allegations by claimant. Allegation of the claimant, and it's written that at the end of verse, allegation by claimant, verse, allegations by claimant, and shall have discretion to treat right of respondent to file such a statement of defense as having been forfeited, shall be inserted. In section 28 of Act, following subsections shall be substituted. 3. While deciding and making an award, arbitral tribunal shall in all cases take into account terms of contract and trade usages applicable to transactions. Here it is, what it says, section 28 of Act, subsection 3. Subsection 3, this is subsection 1, subsection 3. In all cases, arbitral tribunal shall decide in accordance with terms of contract and shall take into account uses of trade applicable to transaction. And what here it says, in subsection 3, following subsection shall be substituted. So that is removed, and it says, while deciding and making an award. While deciding and making an award, arbitration or tribunal shall in all cases take into account terms of contract and trade usage applicable to that transaction. After section 29 of Act, following a new section shall be inserted, namely 29. And that is here 29. Let's go to 29. Decision making by panel of arbitrations. Unless otherwise agreed by parties, arbitral proceedings with more than one arbitrator, and decision of arbitration shall be made by majority of all members, notwithstanding of authorized by parties or members of arbitral tribunal. Question of procedure may be decided by presiding arbitrator. And addition is here. 29A. Award shall be made within a period of 12 months from date and arbitral tribunal enters upon reference, and that is in section 29. 3. It is 3. 29A. I'm sorry. 29A. It is 29A. Where's the other one? 29A. So this is 29A, means 29A here. You can see it's here 29A. One award shall be made within a period of 12 months from date of the tribunal enters upon reference. If award is made within a period of 6 months from date of arbitral tribunal enters upon reference, arbitral tribunal shall be entitled to receive such amount of additional fees as parties may agree. Parties may by consent extend period specified in subsection 1 for making award for a further period not than 6 months. If award is not made within period specified in subsection 1 or exceed 10 period specified, mandate of arbitrator shall terminate unless court has either prior to or after expiry of period, so specified extended period, provided that while extending period under this subsection, if court finds that proceedings have been delayed for reason attributable to arbitral tribunal, then it may order reduction of fees of arbitrators by not exceeding 5% for each month of such delay. Extension of period referred to this may be on application of any of parties and may be granted only for sufficient cause and non such subsection, it shall be open to court to substitute one or all of arbitrators, and if one or all of arbitrators are substituted, arbitral proceedings shall continue from the case already reached and on basis of evidence and materials said already on record, and arbitrators appointed under this section shall be deemed to have received said evidence and materials. In event of arbitrators being appointed under this section, arbitral tribunal thus reconstituted shall be deemed to be in continuation of previous arbitral tribunal tribunal. It shall be open to court to impose actual or exemplary work costs upon parties under this section. An application filed under this shall be disposed of by court as expeditiously as possible, and endeavour shall be made to dispose of matter within a period of 60 days from date of service of notice or opposition parties. 29 would be, so we go further on that. So this is here, you can say 29b is also there. Notwithstanding anything contained in this act, parties to the arbitration agreement may at any stage, either before it or at a time of appointment of arbitral tribunal, agree in writing to have their dispute resolved by fast-track procedure specified subsection 3. Parties to arbitration agreement, while agreeing for resolution of dispute by fast-track procedure, may agree that arbitral tribunal shall consist of a sole arbitrator who shall be chosen by parties. The parties to arbitration agreement, while agreeing for resolution of dispute by fast-track procedure, may agree that the arbitral tribunal shall consist of sole arbitrator. Arbitral tribunal shall have following procedures while conducting arbitration. Arbitral tribunal shall decide dispute on basis of written pleadings, documents and submissions filed by parties without any oral hearing. Arbitral tribunal shall decide dispute on basis of written pleadings, documents and submissions filed by parties without any oral hearing. Arbitral tribunal shall have power to call for any further information or clarification from parties in addition to pleadings and documents filed. An oral hearing may be held only if all parties make a request or if arbitral tribunal considers necessary to have oral hearing for clarifying certain issues. Arbitral tribunal may dispense with technical formalities if oral hearing is held and adopt such procedures as deemed appropriate for expeditious disposal of case. Award under this section shall be made within a period of 6 months from date of arbitral tribunal enters upon reference. If award is not made within the period of specified subsection, provisions of section apply to proceedings. Fees payable by arbitrator and manner of payment of fees shall be such may be agreed with arbitrating parties. So let's now settlement. That's the other one. So if we go to this one, sorry. So we have gone to 29A. Sections 31 of Principal Act. Section 31 of Principal Act, and I think we'll take it later on. It's to do with Section 31 of Principal Act. Following clauses shall be replacement, I think. And 31 in subsection 7 for a clause B, in subsection 7, and that is B. B, a direct sum is some direct to be paid by arbitral award shall, unless award otherwise directs, carry interest at rate of 18% per annum from date of award to date of payment. And what it says now? A sum direct to be paid by an arbitral award shall, unless award otherwise directs, carry interest rate of 2% higher than that current rate of interest payment prevalent on date of award, from date of award to date of payment. Okay, that's the other one. Now 8, cost 8 is unless the price is 8, and what it says here, 8 is cost of arbitration shall be fixed by arbitral tribunal in accordance with section 31A. 31A. After section 31 of Principal Act, following new section shall be inserted, that's 31A. And this is here, 31A, which we are saying, 31A. So that was paused. So we can say, in relation to any arbitration proceedings or proceedings under any of provisions of this act pertain to arbitration. Just a minute, please. Let me have 2 minutes. It is 31A. 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 31A is added. In relation to it is after section 31 of Principal Act, following a new section shall be inserted. In relation to administration proceeding or proceeding under provisions of this act pertaining to arbitration, court or arbitration tribunal, notwithstanding the contained in Code of Civil Procedures 1908 shall have discretion to determine whether costs are payable by one party to another, amount of such costs, and when such costs are to be paid. Cost means reasonable cost. Fees, expenses, arbitrators, courts and witnesses, legal fees and expenses, administrative fees of institution supervising arbitration, any other expenses incurred in connection with arbitral or court proceedings, and arbitral award. Parties, whether any party has succeeded partly in case whether the party has made a frivolous counterclaim leading to delay in disposal of arbitral proceedings, whether it reasonable offer to settle dispute is made by a party and refused by other party, court or arbitrary tribunal may make an order under section, including order that a party shall pay proportion of another party's cost, stated amount in respect of another party's cost from or until certain date only, costs incurred before proceedings have begun, costs relating to particular steps taken in proceedings, costs relating only to agreement which has effect parties to pay whole or part of costs of arbitration in event shall be only valid if such agreement is made after dispute in question is raised in section 34, and that is application for setting aside award. We'll take up later on this one. We'll take up later on, and this is now, you can say,